Hey, chat. Welcome to Friday Night Frenzy. Happy Friday to everyone. We've made it through another week of 2024. Yeah, 2024. It is now April 5th of 2024, 4/5/2024. And I have a special guest this evening to, wrong guest. Wrong guest. Right guest.
I'm not sure actually you do in fact have that right, but I'll take your word for it.
So we had a wild week this week. Andrea, for those of you who don't know, Andrea Burkhart, welcome to the channel.
Thanks, Rob.
Andrea Burkhart is a practicing lawyer in Washington, correct?
Yep.
Western side?
No, east side.
East side?
Yep.
Oh my, so you're in the fray.
I am indeed. I am roughly 2 hours from Moscow, so I've gone to a lot of these hearings in the Kohberger case, and I wasn't able to go to this last one, but planning to be there for the trial.
And I appreciate you trolling me because your Phillies are playing my Nats right now.
They are, and we're up. And I hope you don't take it too personally because, you're getting Aaron Nola. He's our $25 million pitcher, and he tripped so hard in his first start this year against the Braves, a week or so ago. It was like embarrassing, like 7 runs in 4 innings or something in the ballpark like that. So I'm sorry you're having to get his rebound, but that's just how it goes.
It's early season baseball.
Yeah.
It is what it is.
April's rough.
April is always exploring what it is we have on staff. So then we've got March Madness. I've got my Lady Wolfpack playing right now. Lady Wolfpack is currently down 67-45. Ooh, South Carolina's pulling away. But I've got the Gents playing tomorrow, so I'm rooting for my Wolfpack all the way. And Ian Runkle joining himself. How you doing, Ian?
The one time you start on time is the time I'm late.
On time? Andrea looked like she was about to have a heart attack. Andrea doesn't know my MO, where it's usually like I come rolling in here like a bat out of hell trying to figure out what I'm doing. Because, work weeks are work weeks.
Yes.
So
I get it.
Yeah, for the 3 practicing lawyers that are on the screen right now, the work week is usually pretty rough. So trying to cover cases that we're watching is wild.
How you doing, Ian? Your broth looked amazing.
Oh, it was so good. We just had it. There's a ton of broth. So there's going to be ramen for like the next 3 days. And then after that, we're going to have to freeze a whole bunch of it because there's a ton of it. But I am now so full. You just have a bowl of that stuff and it's like drinking a steak. So,
Ian's going to be nodding in a couple minutes here.
I've got some caffeine just to try to help settle that. But for the people who don't know what we're talking about, I made homemade ramen from scratch, which is a giant process.
Mm-hmm.
And it was so good. So good.
Legit too. As soon as he pulled out the tare, I'm like, okay, Ian knows what's up.
No, I don't mess with Ian on cooking. Like there are things where Ian will cook. There are things he won't. But when he decides he wants to go into the kitchen, usually it's gonna be a show.
A lot of the time I'm just too busy to do like proper stuff. One of the things I really like about ramen as a cooking project is that large portions of it are just like you set it up and then you leave it.
Mm-hmm.
Sure, you got it going for 20 hours, but it's just boiling. You add more water to keep it from, boiling down, and that's good. The key is really just boil the heck out of it. Longer than you think you need to, longer than you think anything has any right to be boiled, and good tare, because that's critical. So
that's the secret. That's the magic.
Cooking is so much like freaking woodworking. It's like all in the prep.
Yeah,
it's just
100%.
It's wild. So, how was your guys' week before we get into the topic of the day?
Yeah, I mean, it was good. It was It was kind of hectic. I mean, you mentioned before we came on, I did my very first live stream ever this week. So that was like a huge thing for me. And it was kind of out of the blue too. I was just, I knew the hearing was coming up, and I've been thinking in my mind, you know, at some point soon, I should do a live stream. I should just go ahead and try it out. But I hadn't really, you know, made a decision or pulled the trigger or anything like that. Well, so I had posted something on Twitter about the hearing coming up, and somebody in the comments like, "Oh, are you gonna live stream it today?" And I thought about it. I'm like, you know what? I think I will. So it went from like 3 hours basically from, you know, no plan whatsoever to now I'm doing a live stream, and I thought it went pretty well. So I think I'll keep doing some of that.
Oh, I thought you did freaking great. Like,
well, thanks.
No, absolutely, it was fantastic.
Appreciate it.
People who don't know, like, it is one thing for us to appear on other people's channels. When you are hosting a live stream, the ADHD must be on fire, because you have to manage 9 million different things, so many tabs open, the chat going wild. It is just an experience of itself, and I'm so glad you did it, and I hope that there are so many more of those, because I thought your commentary was awesome, and you didn't interrupt. You did a great job of letting the live stream go. You kept chat questions there, and you remembered to bring all of them back up, which remembering to bring all the questions up is one of the hardest freaking parts about this.
Well, I appreciate it. So, you know, it wasn't too wild. I think the short notice kind of helped. You know, it wasn't a huge audience. I didn't have like a million questions to remember or anything like that. So it was a really good trial run, I think.
Yeah. And you've been covering this case really carefully.
I've been following this case pretty much since it happened. Yeah.
I've got Natalie in the chat. Rob, our son, graduated from Stevens. So Stevens Tech is where I went before I transferred to NC State, before I realized I didn't want to be an engineer like my parents. Congratulations to your son. That's awesome. That's amazing. Hope you guys are all doing well. I hope you had a wonderful week. We've got some spicy commentary, and I asked Andrea to be on here because there are lawyers on YouTube who do deep dives on topic, but I don't think I've ever really, well, you know what? There are exceptions. Ian's coverage of Jeanette Braun.
Have you followed that at all, Andrea? It's a zany case.
I've just heard little pieces about it.
It's bizarre.
Rick Hogue with Anything Gaming. If it's gaming, he's covering it. And Emily with Anything Housewives. It is, my God, she will have the background information. And then Andrea Burkhart with whatever case she is covering, whether it was Johnny Depp or Brian Kohberger. If she decides she wants to go all in and cover it, all of the knowledge, like everything. You're gonna get, I mean, people followed Johnny Depp and learned more about collateral estoppel from me than they ever wanted to know. Oh, collateral estoppel is a great topic. I mean, we could talk about that all day long. But on that topic, we had some developments this week. Wait, I got to swooping. Where is it? There it is. On the topic that we were discussing, Brian Kohberger, the state of Idaho has charged Brian Kohberger in connection with the murder of 4 individuals in Moscow, Idaho, and the naming of it was the Idaho 4, and now it's the Kohberger case. But Mr. Kohberger has been charged and was appointed counsel, and they had to actually go outside of the jurisdiction to find counsel that was competent and qualified to do this case, because it's a capital case. Capital cases require special appointment. You have to have special qualifications in order to be appointed to represent a defendant in a capital case, because his life is on the line. The state is literally trying to deprive him of his actual life. So throughout the process, one of the things that comes up in these pretrial hearings is the possibility that, given the high-profile nature of a case, that there might be a request by one of the parties to transfer the venue, most often the defendant. We anticipated this would be the case from the very beginning. This case was highly publicized. You had people speculating throughout the course of the investigation, and then when the indictment was brought in, you had any number of people on the mainstream media, alternate media, everything, giving their 2 cents on Mr. Kohberger. So we always anticipated that there would be a motion to transfer venue out of Latah, Utah, or Latah, Idaho, to a different forum, a different venue, where we might be able to have a broader jury pool where we wouldn't have so many people that were so familiar with the facts having lived in the jurisdiction. This is particularly important because a lot of people in connection with this case expressed a present fear when the investigation was going on. So there was an added amount of interest in the case during the investigatory process because people were living in the area and people were tracking things that were developing because they had a fear of what transpired, and so no one was apprehended yet. So we anticipated that there would be a motion to transfer venue. What we didn't anticipate was that, well, part
how
of
whiny the prosecutor would get.
Kind of. In any case,
I don't think Andrea can say it. I'll say it.
In any case where you have a motion to transfer venue, one of the burden is on the individual seeking the transfer of venue, and these are heavily disfavored by the court. They really are, and by the law, and for good reason, because the venue where the charge is brought is the venue that is the most appropriate jurisdiction to actually try the individual being charged. They were the community that experienced the injury. They were the community whose prosecutor is bringing the charges. They were the community most affected. They're the people that know the circumstances surrounding this. They are the
all
ones
of those sound like bias to me.
When you have media starting to spin, it can create that. So there's a big burden on getting a case transferred from the originating jurisdiction where the crime occurred to some other jurisdiction. Now, it happens in high-profile cases, but again, burden is on the defense. So what the defense does, the defense has to lay a lot of groundwork in getting there. A lot of groundwork, because it's not just enough to say that people know about the case or it's highly publicized. You actually have to demonstrate to the court. Mind you, this is a judge that is sitting in this court, in this county. You have to say, Judge, I know you love your courtroom, and I know you love this county, but quite frankly, this county and this courtroom is too biased against this defendant to give him a fair trial. If that feels like an uphill slope, it's a freaking mountain.
Yeah.
So defense attorneys will do a lot of groundwork. They'll hire experts to go and poll the area. They have to gather information about just how biased they think this particular jurisdiction is. And
I'll note these applications are fairly rare.
Correct. And I want to remind the chat before we start getting into the topic or getting into the hearing that no party to litigation has to give the other side the inner workings of their case, especially in criminal matters. The state doesn't have to tell the criminal defendant which investigators are investigating what along the way. Prior to that,
there's exceptions. They have to provide the basis for whatever, like they have to provide the evidence they uncover, which is going to reveal a bunch.
You have to provide your evidence, but you don't have to go get permission to do stuff. Like, for example, when the FBI decided they were going to go interview one of the defense witnesses in this case, like the night after she testified in court against them about their IgG practices and how they were, systematically violating people's privacy by using these back doors to get access to genetic profiles of people that had said, we opt out of law enforcement searching. FBI shows up on her doorstep to interrogate her. Did they ask the court for permission to do that?
Sorry, did you say interrogate?
Fancy
intimidate. My headphones are not the best there. It sounded like intimidate to me.
Very clever.
A little bit.
But in the process of developing one's case, you are doing things behind the scenes. The investigators in the police case before the PC affidavit, and before the PC affidavit, they don't have to reveal anything. Nothing. They don't have to tell you you're a suspect. If you are indicted in most jurisdictions, they don't have to tell you that the grand jury is being convened or hearing your case.
Unless you're in New Mexico, apparently.
Yeah, weird case. I actually kind of like that, by the way. I think that system does pretty well. That's a topic for a different conversation. Conversation, those are the same thing.
I think that's my middle name.
Yeah, Ian already sidetracking the conversation. So what ends up happening is the state gets wind of surveys being done, tasked by the defense. And before we get into it, yes, in a capital case where a defendant is qualified as indigent, where they are below a certain threshold as far as financial circumstances are concerned, the state must provide for their defense, which includes the provision and payment of experts. So yes, all of this is being done at the cost of the taxpayers. I want to caveat that because people can have opinions about that. It is the state who is choosing to seek to execute this individual. This is one of the reasons why I make comments about the death penalty and how I used to be in favor of it, and how right now my pendulum has shifted in the exact opposite direction because of the cost involved in the trial practice itself. And take the wrongful conviction part out of it, but the costs involved in trying to prosecute someone where the state is seeking to quite literally execute the individual are substantial.
I mean, they should be doing all of this if they're wanting to incarcerate somebody for a lengthy period too.
Yeah. People are wondering if there is such a thing as a Leo cam, and there is. He will be in that fashion. I have no idea how long this is going to last. We are going to cross our fingers. I'm going to knock on this wooden desk, not loudly, because that's going to wake him up. But yeah, he's just snoozing along. So I'll bring him back up if he does anything fun. That gives us the background to where we are today, where Ann Taylor, who is the appointed defense counsel, remarkably qualified attorney, and I have liked all of her strategies thus far. I mean, she came in like horns ablazing, because she came in and she says, nope, don't tear down the scene. I want to see it. Nope, don't do this. I want to do it. Damn competent counsel. So Ann Taylor contracts with an individual to start surveying the community and surrounding communities to try and build up evidence for this eventual motion that she's going to file. She hasn't filed the motion yet. She is still in this information gathering phase. And the prosecution gets wind of the fact that questions are being asked of
someone reports her
jury pool. And the prosecution gets big mad. They get real upset. And what do you do when you get really upset with opposing counsel? You call them. You sit down, you have a conversation. And they do. They sit down, they have a conversation. And the conversation is, I imagine kind of his prosecution saying, why are we getting wind of this now? Well, you knew I was going to do a survey. Okay, but why are we hearing about these questions? I don't have to tell you my questions, but the questions are really offensive. Okay.
They're not offensive.
What do you want to do about it?
I mean, what are you going to do? Well, we think it violates the non-dissemination order. I disagree. Well, we think it does. And the state goes and they say to Ann Taylor, paraphrasing, here's a joint statement to the court that we would like to file that says these are the questions being asked. We would like you to stop it. The opposing party disagrees, but here are the questions, and we want you to review it right now. Ann Taylor at that point in time very appropriately says, no, I'm not going to file a joint statement with you because I think what I'm doing is appropriate. So they have a difference of opinion. Now you have reached the threshold where you have a difference. You've tried to resolve it. You file a motion. And the state does. The state files a motion on a Friday. And I think I have that. Motion. Where
they do it in the shadiest way possible.
Yeah.
The prosecutor in the hearing takes great offense at being alleged, or at the allegation that he might have filed it in the last minute on a Friday. Whenever an attorney says I take great offense at this,
it means that's exactly what happened.
Yeah, exactly. It means you caught me.
Because if it didn't happen, they wouldn't say, I take great offense at the suggestion. They'd say, that didn't happen and I can prove it.
I don't actually disagree with the tactic. It's a litigation strategy that
I think it's gross in a criminal trial.
Well,
yeah, the criminal trial to use the ex parte process is a pretty big deal.
We haven't gotten there yet, Andrea.
Yeah.
The late afternoon filing itself is frustrating, but within the confines of what's entirely proper.
Sure.
because the prerogative when a late filing comes in is for the court to create a process by which the other side has an opportunity to respond. Unless there are exigencies or emergency circumstances that would justify the court jumping in and saying, hold up, what I have heard is just so bad that if I don't stop this in this very moment, there will be manifest injustice done. And that's where we are. So what ends up happening? Where's the damn motion, Rob?
So the motion, I can tell you this motion itself has not yet been unsealed. They've moved to unseal it, but all we got was Bill Thompson's motion to seal his motion that was, filed also with it late Friday afternoon. So we haven't actually seen his motion yet. It's not available. It's not available.
Yeah, I've got motion to rescind, the motion, the replies, all the replies are there.
Yeah.
But
in the oppositions, I think there's memoranda in opposition. We just don't have his actual motion.
Well, all of this focuses around this particular document. Hang on, let me pull this up. And the particular document in question is this window, not that window, that window. This document, the revised amended non-dissemination order.
Yes.
Now, Judge John Judge is his name. Judge has taken a particular interest in the media coverage surrounding this case. Actually, both parties have. There's been cries of foul play by both sides at the origination. That's the word. Origination of the case. You had the prosecutor one. It was the prosecution's choice to go out and read the PC affidavit out loud in a press conference.
Yeah, that was a choice.
It was. And that's, I'm going to get to that when we get to some of the questions in the back and forth. And then, oh my gosh, Leo just fart. Oh, I'm going to die. Sir. What just came out of your body?
I take it the cheese of the month package arrived for Leo.
This is a closed room. But there was a lot going on, and Judge was very frustrated. And he said, I want all media to stop.
Well, Rob, it's actually even worse than that. I don't know if you remember when this was first happening, when like the arrest was going on and there was just this massive flurry in the media. And part of the problem was that there were all these stories that were being sourced to law enforcement, to anonymous law enforcement sources saying this, saying that. No idea if any of this is true. And apparently, as it's turned out, at least some of it we know is not. And so at least according to Ann Taylor, she's the one that originally wanted this non-dissemination order to be in place because they were having so much difficulty with this bad information being put out apparently by the law enforcement.
And bad information that ends up being cannon fodder for all of the media that's covering the case.
And just a wee bit prejudicial.
Just a bit, I would say. So that results in a back and forth because then the media intervenes and the media says, no, you can't just shut everything down. We want to intervene. We want actually to have access to this, appropriately so. And Judge is now having this balancing act that I don't think he ever foresaw when he said, I want to be a judge in this jurisdiction. He didn't ever see this coming. Mm-hmm. He probably never foresaw a circumstance where he was going to have a high profile case where it's like, now you are cast in between mainstream media, the rights of First Amendment and the rights of the accused. So he was managing it. How he managed it, still subject to debate. Good points on both sides. But in either event, you have this revised amended non-dissemination order. Someone makes sense with the revised and amended. Isn't an amended just an amended?
It's a second amended.
Second amendment. The second amendment.
Wait, it's allowed to carry guns?
I did the same thing.
This is Idaho, Ian.
There's not even that question. Doesn't even. That's not even.
You have to file every court document with a gun.
So Judge enters this order, which says to preserve the right to a fair trial, some curtailment of the dissemination of information in this case is necessary and authorized under the law. Therefore, the following is ordered. The prosecuting attorneys, defense attorneys, and any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family are prohibited from making, my favorite word, extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. Don't say it if you think it's going to have an impact on the case.
And this is literally verbatim from the ethical rules. These are the rules that the attorneys already have to follow just by virtue of being licensed there.
Yep. And that was one of the reasons why people objected to the non-dissemination order, because it was kind of going, well, isn't it just also like the rules? So Nancy Robbins, thank you for the 50 gifted memberships. Immensely kind of you. Thank you very much. And I also have to call out Fiona W. Thank you for the 10 gifted memberships. Y'all have always been amazing. And Joshua, who's one of my mods, why are you gifting anything? Stop. You do enough gifting just by being here. But thank all of you for being here. But yeah, it's the rules of professional conduct that kind of dictates how we're supposed to do this, which, you know, from a conceptual point, you shouldn't have to restate the rules that everyone should be playing by already. But criminal trial
and lawyers.
Yeah, fair. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. And now they get specific. And here's where they start to get into problems for me. Once you go from the broad general rule and you start identifying specifics, that becomes a really big problem, because you have to hit all the specifics, and you have to also make sure you're narrowly tailoring the restriction against the opposing interest of the First Amendment and the right for a public trial. So each one of these specific things is a question. It's a subject of dispute. The identity or nature of evidence expected to be presented at trial, fair. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence at trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The character, credibility, reputation, or criminal record of a party, victim, or witness. Identity of a witness. Expected testimony of a party, victim, or witness. Performance or results of any examination or test, or the refusal or failure of the defendant or a witness to submit to that examination or test. Any opinion as to the guilt or innocence of the defendant. That's directed at the prosecution, because, well, prosecutors. The possibility,
because they had a bunch of those opinions before they
a lot of those opinions coming out.
And this is one of those things where it's like, here's the horse, there's the shit, and we're gonna try and take all of that and just take it and find a way to get back in the horse. If this starts to sound a little bit ridiculous about what people know already at the time the charges are brought, or at the time this order is entered, and what they're allowed to say after it, it starts to get that way.
Well, the problem is that the prosecutor has said so many things that you don't even want them repeating those things, right? Yeah. You can't just say, oh, just because you got all of this out there, and just because you like got off to the races first, like 8 o'clock in the morning, and got all this stuff out there, now it's fine to just keep saying it. It's like, no, shut up. You can't keep doing this.
Yep. You can't talk about the possibility of a guilty plea. You can't talk about the evidence of or contents of any confession, admission, or statement by the defendant, or the refusal of the defendant to make any statement. And you can't give any information obtained by witnesses, the victims' families, or their attorneys from the state that is confidential and has not been publicly disclosed. So 2A or 2 is where we get essentially the exceptions to that rule. So here's the rule. 1 is the rule. 2, the exceptions. Attorneys involved in the case and their agents. So for the prosecutor, state officials, state authority, any person that's contracted by the state, police, investigators, etc. For the defense, any defense experts, any defense witnesses, any defense counsel or consultants, these are all included in that. They are allowed to make extrajudicial statements, written or oral, concerning the following: the claim, offense, or defense involved, and except when prohibited by law, the identity of the parties involved. Fair.
So they can still call it the Kohberger trial.
Yes.
Information contained in the public record.
Yeah.
Now, if that feels broad, because it is.
Yes.
So we have first a restriction that says nobody can say any of these things, but attorneys and their agents can say this, anything that's in the public record. Well, the public record in this case, again, I go back to that choice by the prosecutor to read out that PC affidavit and to put that and make that public. That's not required. I mean, the affidavit itself, like you have to do it. But remember how thorough that was? They went through the cell phone data. They went through the knife. They went through the DNA. They went through in that PC affidavit everything that was publicly disseminated by the prosecution. That is now in the public.
And that wasn't accidental.
No. And here you have an express provision in the non-dissemination order that says attorneys and their agents can give information and make statements about information contained in the public record. If this might seem in conflict with paragraph 1, we're on the same page.
Yeah.
I don't know that this order is really enforceable as to very much.
It's been a problem with this gag order really from the outset. And I mean, like you pointed out, this is the revised amended non-dissemination order. This has had to go through so many iterations because they wanted it to be extremely broad. And, apparently the First Amendment finally crossed somebody's mind and they've had to just systematically narrow it further and further and further to comply with just the limitations on your ability to restrict people's speech. It really does, under the case law, come down to this standard of material likelihood of substantially prejudicing somebody's right to a fair trial. And that gets really murky in a case like this when there's already so much out there in the public square. Some of it true, some of it not true. The overwhelming majority of it prejudicial to the defendant here. Normal First Amendment principles, you have a right to respond. You have a right to defend yourself and to not just allow that to go unsaid. And so there's a lot of ways in which this gag order, I think, has, just in my opinion, probably been a little bit more detrimental to the defense than it has been to the prosecution, because it's really prevented them from being able to correct the record on a lot of this stuff that's out there. But really, my point here is just that they have had to refine this down so much to accommodate the First Amendment that it really just basically says the attorneys and their agents have to follow the ethical rules. And as a result, you're left with this stuff that's ambiguous, and that's been an ongoing problem. It hasn't always been clear who this applies to. It hasn't always been clear what information it applies to. I remember when the first order was out, there was a whole bunch of concern because there were stories coming from law enforcement officers out in Pennsylvania at the time of the arrest, and so the question is, well, are those officers are they in contempt? Well, I mean, theoretically, yeah, but are they even subject to this order? I mean, unless and until they're a witness in his court, it's hard to see, a judge having any kind of jurisdiction over them. So it's really just been a problem with trying to be specific. Like you pointed out, it's got to be narrowly tailored. And that's extremely difficult to do really in any set of circumstances. And it's just created a minefield here with potential conflicts between what the order seems to say you can say and what the order seems to say you can't say.
And the other part here, I mean, a request for assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case. What does that request entail? Can I give specifics when I'm making that request? Can I say we have some evidence of this, but we need more?
Yeah.
Like that right there sets itself up for a big problem.
Yeah.
And then the last catch-all.
Mm-hmm.
Why was this? This order is the problem. This order is the baddie in all of this, because it sets up ambiguity, and where ambiguity exists and where language exists, the court speaks through its orders. So we have the right to rely on the specific verbiage of this order. I have the right to read this order and read it in that language and follow that. And if I am following the restrictions of that order, and if the order has exceptions, I can't be held to account for the court's failure to adequately define what I can't do. So, Jay, they are allowed to make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity, not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. There's a lot of judgment calls that get made in the implementation of that last paragraph.
Mm-hmm.
So that order lays the context for where we end up, which is yesterday's hearing. Let me get that pulled up. This is coming to us courtesy of KREM2, because I won't give Law and Crime the View. And let's see, before we get to there, Nancy Robbins, thank you for the very generous super chat. Rob, can I send you one of my paintings, please? You absolutely may. I will probably display it. Absolutely. You absolutely may. I love people making stuff. Make stuff. It makes you feel better. And Andrea's got some made stuff by her friend in the background, the fishies. Those are awesome.
Yeah.
I follow the artist that you pointed me to her, and I follow her, and she does amazing work.
She's awesome. She's busting out a new mural right now, and it's massive. And I think they're going to have it done in like 10 days or something. I mean, it's crazy.
Yeah, I love it. All right. Let me know if we can hear this. Come on, Judge.
And so maybe
can we hear?
Yep.
We should just start with the state's motion for order prohibiting contact with prospective jurors absent leave of court. Mr. Johnson.
Thank you, Your Honor. And to start, I want to help frame what the issue really is today. We are not here to debate whether the defense contracting for public surveys on public sentiment and that sort of thing is or isn't appropriate. That's not the issue at all.
I agree.
Our sole concern today is the nature of certain questions that have been propounded to residents of Lake Tahoe County by a survey company that's contracted by the defense. And we are specifically concerned with how those questions line up in light of this court's very clear non-dissemination order. I think the best place to start is to go to the court's June 23rd of 2023 non-dissemination order. And in paragraph enumerated number 1, starting at the bottom of page 1, the court ordered that counsel for all the parties and any of our agents and other attorneys are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. And that's essentially the language out of Idaho Professional Conduct Rule 346. But what is particularly important today is the next sentence. Your Honor directed, this order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication It relates to the following. And among the items listed are the identity or nature of evidence expected to be presented at trial or any sentencing phase. Any information a lawyer knows or reasonably should know is likely to be inadmissible at trial, and that would, if disclosed, create a substantial risk of prejudicing impartial trial. And it goes further down to say this includes performance or results of examinations or tests.
But then he did not read out the second part, which is the massive, large exception to that rule.
Concern here is that the questions that were being propounded on behalf of the defense, and let me stop for just a moment. I want to be clear on this. We met with Ms. Taylor last week.
Whenever someone says I want to be clear on something,
week
you're
before
usually
last,
obfuscating.
the 21st.
Thursday.
Yeah.
Before the Friday.
Thursday before the Friday when we filed our motion. Yeah.
Yes.
And we raised our concerns with Ms. Taylor. She confirmed for us that the survey was being conducted on behalf of the defense. And we raised with her the concerns we had about the specific language of the questions that were being asked. And Ms. Taylor represented to us, and I do not dispute this, so that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that
it's kind of normal
we
to
are
let
not
your expert
accusing Ms.
do
Taylor
your
of
expert
drafting
thing.
these questions
You don't tell the
verbatim
expert how
and
to do their job.
say,
Sorry, I had to step away for a second. Yeah. Andrea, please elaborate.
I mean, this is something every single lawyer sitting in that room understands what it's like to have the non-expert tell you how to do your job, you know, that you're an expert in being able to do. Of course, she deferred to her expert that she hired to do the survey. She's not going to tell him what questions to ask. That's his job.
The other thing is that, like, in addressing the whole issue of like which violating the non-dissemination order, if she doesn't tell the expert anything, then arguably it's impossible to violate the non-dissemination order, because the only things the expert would have access to are things that are in the public record.
Information in the public record.
So it seems to me she should be all right. She should be good.
Yeah.
This is where I get frustrated with Ann Taylor.
Yeah. She had a real off day at this hearing.
I was still impressed by her, but there was a lot where I was just like, come on, do the thing.
To be honest, we've all been in a courtroom where it's very clear that the judge is buying what the other side is selling, and you are on the wrong end, and you have a lot of headway to make before you can start going in at the other side.
Isn't it always the government that where they're buying what they're selling? It seems like that's sort of a trend.
It's common.
It's good to be the government.
It is. It's very. This is a tough place to be. So Ann Taylor is now on her heels because the judge isn't just buying. The judge is asking questions that are feeding right into that. Where Ann Taylor's sitting there going, every question the judge asks is going, oh shit, here we go. I gotta go. So, and I'm going to get to this point, and Andrea, you raised it briefly, but I want to get to it when the judge starts talking about the questions more. But the whole idea of who is going to set the metric for whether the question is inappropriate and why the question was selected.
Yeah.
So I hated that this entire hearing bypassed that.
Yes, I did too.
Go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact.
Catch
In
that.
addition to generic questions about the criminal justice
That's
system,
interesting.
here's where we get to
Somebody
things.
recorded this and sent it to the prosecutor. Now, it
Now, does that
turns
not
out
tell you
that
that there's
4
some bias
people
in this?
in total call the prosecutor out of the 400 people that are surveyed because they're so concerned. 1% of the respondents called the prosecutor to tell them this was going on. Does that sound a little biased to you?
I mean, to me, it sounds like there's a bias, because why would you call the prosecutor about this? Why would you be like, there's anything wrong with this?
Well, let me give you.
I've never heard of anybody, calling mom on this.
Give people the context. So the context is that a random phone call comes to your phone. It is not announced that it is in relation to the case. It's not announced that it is on behalf of any person that's a participant of the case, not a prosecutor, not a defense counsel. It's just a question asking you, ostensibly, about your observations of the media surrounding this high-profile case. So no indication as to who's asking it and the questions you get asked. And it puts the person on such high alert that they immediately send it not to the defense. Remember, the defense asked for the non-dissemination order.
Mm-hmm.
Not to the defense, but to the prosecutor.
Yeah.
I do understand why someone might reach that conclusion, who's a person in the area, who lived in this fear, who experienced this horrible circumstance occurring. And again, I am taking the facts of this case out of my analysis when we come down to the process itself, the motions being argued, and trying to get to the trial and making sure it's fair. Is my fiance in the chat? Did you show up, Mischief?
I think she might have.
Hi. Leo's doing fine. He's sleeping. He farted 3 times. But that's an interesting development because it was being recorded and sent on.
Yeah. To make a transcript of this thing.
Things that concern the state immensely. Question: have you read, seen, or heard if Brian Kohberger was arrested at his parents' home in Pennsylvania?
First question that's of concern, right? Have you read, seen, or heard? Read, seen, heard. That Brian Kohberger was arrested in Pennsylvania. Okay.
Well, that was widely reported.
That was.
Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims?
Knife sheath on the bed.
It's in the PC affidavit.
Yep.
That Bill Thompson read.
Widely reported.
Out loud.
Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Kohberger?
Also in the PC affidavit.
The PC affidavit.
Question: have you read, seen, or heard if Brian Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred?
PC affidavit.
Have you seen, read, seen, or heard if the cell phone tower data showed that Brian Kohberger made several trips near the victim's home in the month before the killing?
PC affidavit.
Yep.
Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Brian Kohberger was arrested for the murders?
So all over the news.
Media reports.
PC affidavit and news at large.
Yep.
Is he trying to get himself thrown out of the case? Because is he trying to get himself thrown out of the case?
Oh, no,
he
no,
put
no.
all of this stuff out in public.
No, he has privilege, of course, to be able to say this in the courtroom setting.
And I'm gonna get to. I've watched this hearing 4 times already, like start to finish. And the first time I watched it, I heard the question. I was going, "Well, those are questions. Like those are intense." Second time, Third time, where'd the questions come from?
I mean, what else are you going to ask prospective jurors?
Wait, I have a thought process on this one that I think Anne should have. I really think Anne should have driven this home. Let me list the last question.
Kohberger said that he was out driving alone on the night of the murders.
PC affidavit.
That's in the alibi defense.
Say again.
The notice of alibi.
Yep. So public filings, already filed, disclosed. They're there.
Heard if Brian Kohberger stalked one of the victims. Have you seen or heard if Brian Kohberger had followed one of the victims on social media?
These are from Coffendorfer and Gonzalez.
Well, here was my thought process. Whoever the expert is, Edelman, his name, right? There was a calculation. The topics that he chose to interview on were prosecution statements. So when the finger gets pointed back to the prejudice or the bias or where the information could have been drawn from, that finger can get pointed right back at the prosecution. It was their choice to read that out loud and to let that get publicly disseminated. And I get the point for the prosecutor. It was to allay public concern that there had been an arrest. I understand that part. Those questions, while they seem kind of intense, and yeah, they're a question that.
And I mean, you can allay public concern without what they're doing here.
Yeah. I listened to those the first time and I said, well, there's hints of the evidence produced. But then I was going, why is the prosecution arguing so hard? Because the prosecution might choose or not choose, or choose to or not introduce any of those things at trial, things that they laid out in the PC affidavit as being the basis for the arrest. Because maybe some of that might fall through.
They're also trying to box the defense in. You see them ask for a very specific. They want the defense to have to follow very specific rules.
They want to decide what the questions are.
Yeah, and specifically, they want the question to basically be the questions you'd ask at a voir dire. Like, can you not put this aside? And that's not what you'd ask at this stage. They want to box them into questions that are basically like, are you so biased that you couldn't possibly do this? And that's not what's being told. So they want to basically pin them to something to prevent the change of venue. And it's kind of gross. Like, it's kind of ugly. And it looks intentional to me, but
to me, the reason I find it offensive is because anybody who's done a voir dire knows how ineffective it is to do that approach of, well, can you be fair? You know, it's so pointless. Nobody is ever going to say, no, I can't be fair. Everybody thinks that they can be fair. And so it's only when you get into the specifics that you can really kind of get some meat on the bones of what it means to be fair in a particular case or not. Oh, it turns out that you were a victim of a similar crime. Oh, and that happened. Oh, and you've had mental health treatment because of that. Oh, and don't you think that's maybe going to disturb you a little bit to be going through the same type of trial here? You have to get into the details to explore it. And so there's just no feasible way that you can talk to potential jurors about the impact of media coverage and including false information that's put out there in the media without being able to ask if they've heard it and what sort of effect on them it had.
Well, and my other part is like there's the argument of, or not the argument, but there's the whole where someone gets up and says, I can be fair and impartial, but we have to assess the credibility behind that statement. How do we assess the credibility? What is the foundation of their knowledge at that point in time? What do they know already going into that statement? If
people
I
literally walk in wearing a shirt that says hang Brian Kohberger and they would say I can be fair.
If I already know 10 different facts and I say I can still be fair, I'm a lawyer. I feel pretty damn good about my ability to sit on a jury and be like, I can put the facts aside. But we've seen judges, we've seen jurists, we've seen Supreme Court justices, we've seen all these people who are very trained experts in legal practice. And when they say I can put these facts aside, all of a sudden in their ruling, you start hearing those facts. It is
well, and it's just It's part of the hubris of the human condition that we think we're so much more in tune with ourselves than in fact we are. I mean, and that's really the point of certainly what this expert talked about, at least very briefly in his declaration, but it's also come up in other contexts and previous filings in this case. The way that bias works, it's so insidious, and the type of effect that it has on people is typically going to be something that you are not aware of.
Yep.
And that's the whole problem with this pervasive type of media, particularly this false information, is the way that it just poisons people without them even realizing that they have that knee-jerk reaction to it.
Exactly. The subconscious bias that you start to develop, it's not something you intentionally do. Hell, you could be focusing every ounce of your intentional being at not being biased. But knowledge that you have in the foreground or in the background is influencing how you perceive the facts being presented to you.
You've already been anchored to he's a creepy incel, and that is going to color how you see what happens in the courtroom. You are going to perceive things differently if that is already implanted in your mind than if you walk in completely cold, you've never heard of him before, you have no idea what type of background he has. Your perception, you will there's a good likelihood you will literally see different things in the case than somebody who's got a different impression.
Oh my God, the chat has so many good questions. So many good questions. Just Amber, isn't this work product? That's part of what makes me feel really uncomfortable.
Mm-hmm.
I want to remind you where I started discussing this was that an attorney that's preparing a motion is doing a lot of background investigation because they have a big hurdle to jump in front of. And it tips the scales away from their advantage that they had if that information becomes privy to the public or the other side at an early stage. So right now, I'll get to that a little bit later, but this kind of broaches on the possibility of work product. Caitlin says, if they're asking questions like this, they need context. The following statements are in the public. They may or may not be true. Have you heard them? The survey didn't do that. And
we don't know if the survey did that.
That's what I mean. That is my frustration.
Mm-hmm.
We don't know. All we heard was the prosecutor relaying specific things that were asked. 1, 2, 3, 4, 5. We don't know if there was any question asked either before that, after that, context given, or what the previous 3 pages of questions asked. That frustrated me with kind of how this hearing went forward.
Mm-hmm.
The focus should have been on what questions were being asked and why.
Why were these questions asked, and why did they need to be these questions? We got a great declaration from an expert telling us that there are specific professional standards for these things. There's a reason why things are done the way that they are, and the survey that I compiled and administered complies with all of these standards. Well, great. Give us the details. Tell us then why was it important to ask them about these specific facts and to do it in this manner?
And this one is the other one I want to bring up, Kat. And I completely understand how people disagree with this. I do. I want to be honest with this one. I saw a lot of people going at Ann Taylor for this questioning for the survey because it feels interesting. It's difficult to process. It's very difficult to process. But
I mean, if you were trying to tape a jury, this is an incredibly expensive way to do it.
And it's
not very effective. 400 people out of a county of 40,000. It's not, you're not going to get there.
And it's very counterproductive. It's not going to do it.
You might as well buy a lottery ticket. And she didn't even pick the questions like her expert did.
Well, and what drove me the most nuts about this, how many people responded yes to those questions?
We don't know.
Yeah.
I wanted to, when I was hearing those questions, I was going, whoa, those are intense. A lot of very specific facts about the case. Yes, they're publicly reported on. How many people said yes?
Mm-hmm.
And it went to the question that Andrea raised beforehand. When you ask people if they've heard about the case, you'll get some shrugs, maybe a little bit here and there, but you don't get anything specific. But the second you ask them about a question, did you hear about a knife sheath? One, they might not have recalled it.
Mm-hmm.
So they might just not have a fresh recollection of, oh yeah, there was a knife sheath involved.
But
So
there's no other way to test whether specific issues have sort of permeated themselves into the public consciousness.
and
That's going to be the question, is like, are people talking about this stuff at coffee shops?
and
Are people, that's what they really need to get to. And that's what the prosecution's trying to prevent them from knowing.
And let me give you an example. Let me give an example of a voir dire question. So let's say that there's a witness on the stand, or there's a potential juror who's being questioned. And the voir dire begins, because with this high profile case, the voir dire begins, have you heard about the Idaho murders? Yeah, I saw it in the news. Did you hear about an arrest involving those murders? I saw the arrest. Yeah. Did you hear any specifics? I don't really remember. Do you think, despite any news you heard, that you could be a fair and impartial juror? Yeah, I could. Now, halfway through the trial, all of a sudden the prosecution or the defense makes some argument in the presence of the jury about evidence that might have been excluded, right? Like the sheath. Let's say the sheath does not make it in, but the sheath gets mentioned. And now this juror, who had stated early in their voir dire that they had some knowledge of it but didn't remember specifics, here's the word sheath, and they go, oh yeah, wasn't there DNA on that damn thing? You can't get that out of voir dire.
Mm-hmm.
You cannot get to that. And lo and behold, there was a Trojan horse on the jury the whole time. That's the fear. So I get why the questions have to get to these specific statements.
It's not just a fear, it's a virtual certainty. Like right now, it's the odds that they get, like if they manage, like let's say they exclude the knife sheath or they exclude the DNA results, the odds that somebody in that jury room hasn't heard about it is basically nothing in my.
Yeah.
But in order to make the argument, they have to actually bring the evidence to say, like 70% of people have heard of this. How are you going to poll a jury when 70% have this bit of information that may be deemed inadmissible?
Mm-hmm.
And sorry, Andrea, go ahead.
Oh no, I'm just agreeing with what Ian's saying.
I was going to say that's what brought me back to watching this hearing for the second and third time. First time I hear the question of going, those are intense. Second time, no, I get it. I understand it. And to the second point of Kat, and by the way, disagreement, completely fair game. 1000% fair game. On the being disingenuous and deliberately trying to taint the jury pool, let me point back to the prosecution's decision. The prosecutor held a press conference and read that PC affidavit. They didn't just say, file the PC affidavit that has all these facts. They went out and on the broadest public stage, at the height of media coverage and speculation, when every single eye was on this case because they were trying to catch somebody, they read the PC affidavit. So who was trying to take the jury pool?
Yeah. Reached a lot more than 400 people.
Like who was trying to taint them? If you're looking at the effort, is it the 1% that gets asked the question several months later, or is it the original statement that gets broadcast far and wide? I'm not saying that either one is great, but it's reality. This is another good one. I can't wrap my head around why the defense wanted to put these questions in the minds of the public. Ian answered that. How do you get to the specific facts? How do you know whether the juror knows these specific facts? You have to somehow get to these questions.
You don't deal with an elephant in a room by just pretending it's not there. You have to call it out. That's the whole point.
And I mean, the defense would have no problem saying, hey, you were one of the people we surveyed. You should not be on this jury.
Mm-hmm.
Like, that's not even the question. It's just, is this poll of 400 people enough to pollute the jury pool such that, assuming that we could get a fair jury before, that we can't get one now? And it's like, if 400 people is enough to do that, then You know, now if she, like, let's say she goes crazy and she polls every single resident of Latah County.
Well, that's a problem.
The court would have a different remedy in that case, but that's not what we're looking at. We're looking at polled a few, like, so.
Yeah. And the
consistent by all representations with the professional standards for polling in these types of issues.
Yep. So, and it's one of those things where this question becomes also relevant. Mama Smith, are typical survey questions more open-ended? Have you seen? That's voir dire. Voir dire are open-ended, where the judge asks the open-ended question, have you seen or heard? And either the judge or the attorneys will try to narrow down in focal points on what they actually have seen or heard. But that's also within remarkable constraints. Very different stage of the process, very different thing.
Mm-hmm.
Voir dire can be responsive to the answers, like in the sense of, I ask a juror a question, they give an answer, and based on their answer, I go on to ask the next question. Like, have you heard anything about the Kohberger arrest? Mm-hmm. And the person says no. So I'm not going to start asking them specific details because now I'm feeding them that information. But you can't do that with these surveys because every single survey participant has to have received the same pool of questions. Mm-hmm. So you can't do that like rolling questioning kind of thing that you do on a voir dire. It's a completely different world, different scenario. So
I want to correct this. No, 400 because the judge made a stop on Friday. No, they were done.
They were done with Latah. Yeah.
They were done.
Yeah, they were going to look at some other counties.
Was all they had done.
Yeah.
Peter said the questions were leading and they should have been phrased differently.
No, it's not leading. I hate this. Okay, I have to call this out. I hate it. I hate it. I hate it. It is not a leading question to ask something that has a yes or no answer. A leading question is when it tells you what answer is expected in the form of the question.
Would you like to give an example?
You have heard about this would be a leading question. Have you heard is not. You can freely answer yes. You can freely answer no. It is not leading.
Yeah. So, yeah, like I said,
now there can be yes or no questions that are leading. Like, did you find a knife at the scene? Is leading, yes. Because you know they had if the witness hadn't mentioned a knife,
they would
and
never
you're saying like a knife out of nowhere, it's leading because why else are you asking the question, right? But if you ask like, did you eat breakfast this morning?
Now,
not leading.
The other part about leading is leading requires context. You have to know the questions being asked beforehand to know if this particular question is leading in nature, which gets me to this question. Do we know exactly how the poll was run? No.
Well, the other thing is
the record. We did not get our record. And that's what irritated me about Ann Taylor's decision-making during that hearing. We didn't get the record.
The other thing though, is that this poll isn't a court proceeding. So the rules on leading are for court proceedings, not so much for surveys. Now, it shouldn't be a push poll, but the prosecution hasn't alleged that it's a push poll, right? And a push poll is when you're trying to change people's minds with a poll. Like, so you'll get politicians who are like, do you support, fictional politician A's decision to let a sex offender out on the street in your neighborhood? Like, the point isn't the question. The point is that they want to tell you that this politician is bad, right? You can't do a push poll on this, but the prosecution isn't even suggesting this is a push poll.
The implied problem with these questions are not that they're leading, it's that they are potentially suggestive. That's the problem. If you haven't heard this information, now the information has been suggested to you and you can consider it as a possibility. If you're taking it at face value, they're asking me because, this is real, then that's the potential problem with it. But again, without a bigger context of exactly how this survey was structured, how it's set up to mitigate the risk of that kind of thing, why, these standards are set the way that they are to be able to get the information that you need with the limited amount of downside to that. We just, from my perspective, we're not in a position to be able to evaluate it. We needed to hear from that expert.
Yeah. And I wanted to know what the answers were. Because if the answers were 70% yes, holy shit.
But the other thing is that the prosecution didn't even, like, it's the prosecution who's complaining about this. And they didn't even get us to the issue of, like, there's definitely a problem with this. They got us to the issue of, like, well, the prosecution's very upset.
Mm-hmm.
They did, but in the judge, they didn't get us to there's a problem with this. They asserted that there's a problem with this.
Right. But they've got this transcript.
Yes.
So if they're not able to get us there and to, like, show us clearly why we're there, I don't think we're there yet.
Yep. All right. I want to pull this up real quick. Hem 2,478, 2,512 unit right now. Watching 911 likes. Come on, guys. We can do better. Yes, please like the stream. Please like the stream. And if you like the content, please consider subscribing and subscribe to Ian Runkle, Runkle the Bailey, and Andrea Burkhart, who's going to be going live a lot more in her coverage of the Brian Kohberger case, because the woman knows more about this damn case than I think any other lawyer that's talking about it. So I want to get to the second part before Andrea has to go, because I know she has a hard cutoff at 7 her time, which is 10 p.m. my time. Let's get to the procedural due process, which is when Ann Taylor first gets up.
Be good.
I'll come back to that.
Yes, sir. Thank you.
I'm concerned about that, Ms. Taylor. So go ahead. Your turn.
Your Honor, we have Brian Edelman ready to testify by Zoom about these surveys if the court would hear his testimony.
First, I want to hear about the process. I care more about how.
He cares about his ego, which is fair. I get it. The accusation was levied that Judge entered an order ex parte without hearing from both sides.
Because he did.
How this came down than what he did. Although I just learned for the first time that you had nothing to do with the questions.
I didn't write the questions, Judge. Those questions are generated by Brian Edelman, and he can tell you who he is and his educational background and why the questions are crafted as they're crafted. But I approved him doing this survey. This is not an anomaly. These kinds of surveys are done in high-profile cases quite often. I don't know how I could present to the court what's going to be required at the venue change hearing without understanding what is going on with the public. This is an anonymous survey. This is not one where anybody's identified as far as the defense wants to know this or the prosecutor wants to know this. It's a random survey, and there's a reason why there are general questions and more specific questions. And Mr. Edelman can explain that, but I'll do my best to paraphrase that.
Okay, well, I'm just curious. Did Mr. Edelman was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no information in the case, Your Honor. He received nothing from us as far as no police reports, no contact with our client, no interviews. He received no information.
That should have been the end of the inquiry. Because if he didn't receive any information from them, everything he is speaking about is from the public record, which is that to be exception. End of story, period.
Entire construct of this survey is as he does in his high profile cases. He pulled the media local to this area to see what the most common stories were. Those are things that are in the public arena. Though this court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I didn't like this. I know, and that's why I paused it, Andrea. Go ahead. Go ahead. I've got the same thought.
Well, it's just you know, this is a problem. Why is this funny? I mean, why is her pointing out that it's in the public record funny? He seems to be laughing like that doesn't matter, and it clearly matters. That's at the heart of the gag order. And that's why you found this was such an emergency that you had to do it on an emergency basis on a Friday afternoon without any notice.
Yep. And we're going to have this argument right now, Saskia, because it's not, I'm not arguing with you. It's me arguing with the concept.
It's not poisoning the jury pool when it's 400 people.
And
not
only that, the judge entered a non-dissemination order. The judge was 1000% in control of what these participants and litigants could say and disseminate. The judge drafted that order specifically to include a very specific delineated carve-out for information that was already in the public record. So I mean, when the judge's own order says specifically, you are allowed to do this, I am allowed. You know, Ann Taylor could go out tomorrow, hold a press conference and say, this was an article that I saw the other day. She can do that based on this order. And the judge might be pissed, but the only person the judge can be mad at is himself for drafting the order way he did. And
the other thing,
yeah, go ahead.
Let's say I've got a jury trial, you know, and we don't have the jury selected yet, but you know, it's a jury trial, so there's going to be one picked at some point. And I just and I have a birthday party, and I decide that at my birthday party there's going to be an open bar, and so everyone who wants to show up can show up. And 400 people show up, and I end up buying free drinks for 400 people. Before the jury is selected, that's not going to be an issue. The court is not going to be able to take issue with 400 random people showed up at your birthday party. You're trying to taint the jury pool. They might allow the prosecution to be like, hey, did you go to Runkle's birthday party and have his free booze? And if so, you're off the jury. But now, it's a very different thing if they've already impaneled the jury and they've got 12 jurors and 4 alternates, and I bring those 16 people to a bar and buy them free booze. I'm getting disbarred. Yeah. Right. So I see somebody saying, do I actually believe that none of those 400 people spoke to anyone else? The prosecution did press releases. Wait, even if each of those people talks to 3 people, it's not.
hang on, because I brought this one up too. But people talk. Did you get called by Kohberger? No. What they ask? The pool is tainted. Here's the big freaking elephant in the room. We don't talk about elephants in the room. What I want you to balance the equities, balance the understanding of what would possibly taint a jury pool, please, for a moment. Random phone calls to 400 people and the people they might talk to, or the prosecution filing a motion, a public hearing via Zoom that's going to attract the attention of every mainstream media outlet, which it already has, and the prosecution reading aloud the specific questions that were asked of those 400 people. Which one is going to have the broader reach? Which one is going to have the more negative impact on the jury pool? You answer, because if your answer is the 400 people that were called, I'm sorry, you are objectively wrong.
Well, and ultimately, here's the other thing. If you think those 400 calls are enough that the jury pool is now tainted, there is no way to escape the conclusion that by your logic, the jury pool was tainted before they made those 400 calls. Yeah. Because the press releases, do you think the people who watch those press releases don't talk to people? So if you're saying that 400 people has tainted the jury pool, then you just have to grant the motion to move it out of the jurisdiction. There is no other option.
400 people is literally just a sample. I mean, it's there to be representative of the community at large enough so that you can extrapolate with some kind of, statistical certainty, significance, such as it is. So, I mean, I think a big problem here, like Robin and Ian have pointed out, how many of these people said yes? They have heard these things. If they've already heard these things, how are you tainting them to ask them if they've heard it? The only people that are potentially tainted by this in any way at all would be whatever subsection of the 400 people had never heard of it before and are hearing it for the first time. And now you know, if they can't put that out of their minds and they can't, you know, go on to serve as jurors in spite of just the overwhelming flood of information that has already been put out in the public arena about this case. Like, how is this going to make the difference? To me, it's infuriating because it is such a double standard. And when you're a defense attorney, you get real used to that. You get used to there being different rules for what the state gets to do and what the defense gets to do. And it shouldn't be that way. That is absolutely not fair. They should not be in a position of having to ignore the elephant in the room. That's not the requirement.
The defense, and to this question, the defense complied with the order 100%. I am sorry. Other people might have different opinions, but we read the order out loud. I pulled it up right on stream. The attorneys and agents for the attorneys are allowed to disseminate information that is in the public record. And when Ann Taylor got up and said they had no material from my file, and when we heard the questions, which were absolutely already in the public record, that is not a violation of the non-dissemination order. Period. End of story. Not subject to debate. Clear black and white language. That's it. Now, I imagine the conversation between Ann Taylor and the prosecutors when the prosecutors found out about the survey was they were saying, we don't like the questions. Ann was saying, I'm sorry. That's your problem. Prosecutor says, we're going to file a motion. Ann was saying, if you file the motion, you're going to make it worse. Don't file a motion. Prosecution said, here, sign on to this joint statement. No, I didn't do anything wrong. Prosecution said, fine, we'll file a motion. Ann says, don't do that. That's stupid. They file a motion. Ann scrambles, files a letter in response because she was trying. They filed a motion on that day.
I imagine that there's a lot of just like her going, as they're explaining
it was probably her saying, oh, like screaming and just running to her computer, trying to change the letter that she was drafting to somehow address what was just now made public in that file, just now became part of that filing, knowing that that was now going to be a part of the public hearing. That's a big problem. This hearing is a bigger problem than any aspect of the survey. So I understand people being frustrated with Ann Taylor. I get it. You don't like defense attorneys get a bad rap. They're gonna keep it. They're gonna take it. They're gonna keep on doing their job. She did not violate the order. The gag order expressly allowed for her or anyone working for her to go out and say, this is public knowledge. I'm going to go ahead and re-say that again.
And one thing that she did do too that I thought was quite a boss move was she pointed out the limits of this order. They are coextensive with the ethical rules. Are you accusing me of violating the ethical rules? And Bill Thompson backs, oh, no, I'm not making any kind of accusation like that. The judge doesn't want to go there. The prosecutor doesn't want to go there because they know that's not what happened. But if she didn't violate the ethical rules, she didn't violate the order.
Yeah. It's like, make a bar complaint or we're done here.
They just want to be the puppet master over the defense work. They see it. They don't like it. They want it to be different. But I mean, quite frankly, it's just not their concern. How tainted is it for, during this whole investigative process? We've heard about thousands and thousands of tips that were received and interviews that were conducted and things like that. Conversations that law enforcement is out there having with members of the community about this case. You think that hasn't tainted people? I mean, it's just, it kills me that so much of this effect can be attributed to the state, and the tiny little risk of downside that could potentially, I guess, be attributed to the defense in this, that's going to be the whole problem that we focus on. If the defense has to potentially bring up information to people that haven't heard it before, in order to address the elephant in the room that they did not cause that problem.
Yeah, I also want to address.
But they're somehow the bad guy in this.
Yeah.
It kills me.
I want to address this comment because I think it really gets to the substance of what we're looking at here. Yes, they didn't want the information out there in the first place. Now that the prosecution has put it out there, the only way to assess the damage that the prosecution did is by asking questions that deal with that. And so if they're not allowed to ask the questions specifically about, did you hear these things? Because that's really what they're trying to do, is they're trying to show that the prosecution has tainted the jury pool. They have to be able to ask these questions in order to deal with that. So yes, they didn't want that out there in the first place.
Mm-hmm.
But now that it's out there, it's like saying, you can't go out and test for syphilis because you were upset about there being a syphilis outbreak. It's like, well, yeah, that's how we look into it, is we actually test for the thing. The prosecution now is trying to say, basically, you can't get this information
after they put it into the ether. And
I also want to say it is 100% certain. Let's say the prosecution wins this and they win this issue, and the defense is precluded from asking these questions. It is 100% certain that the prosecution later, when they're applying for the change of venue, says, we don't have specific enough information.
Guaranteed.
Yeah. Oh, yeah. Guaranteed.
So I want to make one point, and I want Andrea to address the next question before she has to roll out. The one point is, people are being mad about yes, she threw it back on the judge. In my opinion, she could have and should have thrown it back on the judge even further.
Mm-hmm.
The judge is in control of the orders the court enters. A court speaks through its orders. If there's ambiguity as to what the intention of that order is, that is not on the parties. That is on the judge.
Mm-hmm.
I was critical when this judge made this non-dissemination order in the first place.
Mm-hmm.
One, I thought the first one was way too broad and he scaled it back. But two, when you try to scale it back and you realize how much public has already been commenting on this one, you got to be real careful. And there was not a lot of care put into the language, specifically the exception of what the lawyers were allowed to do.
Mm-hmm.
Ann Taylor, not only was she not violating the order, she had an ethical obligation to her client, an absolute obligation to her client, to do everything within the bounds of that order that would give her client an advantage. If you don't agree with that, that's fine. The US and the country, this might not be the country where you want to be right now. I get it. But that is how criminal defense works in the United States. That lawyer has an ethical obligation, not just to follow the court's orders, but to push right up against that brink for the benefit of their client.
The other thing is, she could have come harder at the judge by saying, listen, like if she'd wanted to, she could have said, hey, you don't get to decide. Like, I want you to recuse yourself on this issue of whether or not this is a violation, because you already made a decision so because you've already made a decision on this topic, there's now a reasonable apprehension of bias. You have to recuse yourself. She didn't do that. And that might have been an error, but it might not have. I mean, I don't think the judge would have, and she just would have pissed him off more. So
yeah, he wouldn't have. No way.
The last one I wanted to get your opinion on, Andrea, I'm sorry we're cutting you off. I just know you have to go.
Yeah.
Was this due process issue.
Yeah.
Can you give a summary of what transpired and why you had concerns with what took place?
Yeah, well, so the way that it was described is that the state, first got tipped off that these calls were going out in early March, and then they referred it to the law enforcement to go out and investigate. Law enforcement then was able to figure out that, oh, this is the defense survey. They get more information about it. They get more calls coming in. They get this transcript. So then they set up a meeting with Ann Taylor when she's coming over the next day so they can talk about it. They talk about it. She, answers their questions, confirms it's a survey, gives them the CV of the expert. No idea if they contacted him or not to, maybe ask him, what's this all about? They have a conversation because the state is clearly concerned, and like Rob said, indicated they they aren't going to be able to reach an agreement on it. So they want to go to the judge. And Taylor suggests, well, let's set up an in-chambers meeting with the judge. Okay, in-chambers meeting so that we can talk about this behind closed doors and not have it all part of the public record. And the state was not, amenable to that. She indicated, short notice hearing is a possibility. They weren't amenable to that. And so instead, what they did is they filed the last minute ex parte motion on Friday afternoon, meaning basically she doesn't have a meaningful chance to respond to this before the judge is going to take action on it, before he's going to do something that has a legal effect, orders her to stop her work on the survey. And she hasn't, had an opportunity to do more than just, very quickly give, the response that you can put together in a couple of hours. Maybe she doesn't have time to get the declaration from her expert, to get the context that he needs and all of that information, but he's there making a decision without hearing and without notice. That's what she's getting on about with the due process issue, because I mean, even in civil cases, the right is there to be heard at a meaningful time and in a meaningful manner. This is a criminal case. This is a death penalty case. There's kind of a lot at stake here. So,
Andrew, you do federal work, right?
No, I don't do federal work.
Okay. In your court, in federal court, if I file something, right, and I ask for a ruling, even if I ask for ex parte,
mm-hmm.
I will get, because the judge's law clerk is usually really on point with this stuff, I will usually get an email back from the judge's clerk saying a response is requested by such date.
Mm-hmm.
Like the judge views the emergency, says it is an emergency, and says you are now obligated to file a written response by this date, usually 24 hours. You have the opportunity with the judge telling you you have 24 hours.
Mm-hmm.
This was, now I think Ann Taylor quasi shot herself in the foot
mm-hmm.
by filing that letter.
Mm-hmm.
Because the judge, how many times did the judge throw that back?
Yeah, you got a chance. You responded. You got a chance. And now we're having this hearing.
And you look at her supplement, and her supplement has a lot more of the detail, a lot more of the context about the survey, which sucks about this entire hearing. We don't get to any of the things we wanted to hear. And Andrea, I'm sorry you have to go, but that's where I kind of wanted you to tune in. Like, there's upcoming hearings. What are you covering? What do you want to hear?
So they're coming back to this on Wednesday. And I mean, the way they seem to leave it was that they're going to talk about whether they can continue to finish the work that they've started. It sounds like a foregone conclusion that they're, not real receptive to asking, to allowing these questions to continue to be asked in the other counties for comparative purposes. But we didn't hear from the expert about any of this on Thursday's hearing. So I really hope we hear from this expert on Wednesday. I don't know if we're going to. They suggested, and you need to go back and talk to the expert about what's going to be feasible. So I don't know if she's just going to back away from this, survey that they've initiated already and kind of concede that and try to start over. I don't know what to expect at Wednesday's hearing. A comment I made on my own stream that I'll just reiterate here is, I think one of the big issues is the way this judge likes to operate. He likes to operate by consensus. And the big reason why he likes to do that is because if he can get the defense to buy into whatever it is that he's suggesting, then they can't raise that as an appeal issue. That would be an invited error. They basically went along with the judge's ruling. You don't get to sandbag him and then claim later on that that's an error. So that's been a consistent pattern that he's shown with his decisions throughout this whole process. And he pretty clearly to me seems to be trying to work something like that up on this as well. I really, really want her to resist that. And, like you said, when you're a defense attorney, your job is not to be liked, and it's often the case that you're not going to be. People don't like what it entails to do your job. People don't like the people that you're sitting next to and working for. They don't like the fact that you're on their side. But that just is the way it is. And so I hope that she does what she needs to do to make this record of what needs to be done and why it needs to be done, for the exact reason that you guys pointed out. When this motion comes forward down the road, they're going to need to have a specific showing to meet the standard if they're going to have an expectation of moving this out of county. And we can already anticipate the state is going to be challenging that. They're going to be arguing you haven't met your burden. So this impediment in her ability to investigate the facts that she needs to be able to put forward her motion, this is fundamental to the right to a defense. I really want her to stand firm on that. I want her to get the expert on the stand and clear out a lot of this information. So anyway, I will be live streaming it on Wednesday. So feel free to join me then. I do have to dip out now, guys. I really appreciate the invite, Rob. It's always fun to be here. We need to do it more often.
Remarkable coverage. You guys, you're going to find any number of lawyers on this platform that are very good lawyers, people that have remarkable takes and are very bright and brilliant and arguing their positions. And the great thing about it is you get it from a very broad perspective. Andrea Burkhart is one of the best that's out there, as far as when she decides that she wants to cover a case, you don't get half-assed. She knows these pleadings probably better than anyone else on the internet right now. So I really appreciate her take, and I appreciate her taking the time. Please go check out her channel. I want to see that channel just go to the moon, especially now that she's live streaming and giving honest coverage on what she's seeing in the Kohberger case, which is going to keep on getting traction. So thank you for being here, Andrea. I really appreciate it.
Thank you so much. Really appreciate it. See you guys later.
Yeah, I think the only person who or the only people who actually have a better grasp of the pleadings are all subject to a non-dissemination order right now.
I don't even know if that's the case. I don't
actually. That's a fair point.
Think that Andrea probably knows them better than they do.
Yeah, you're not wrong on that. So,
and I wanted to kind of mention, because people are screaming in the chat, "Where's EDB? Where's he?" Because I know Emily had a different take on this. Emily's a former prosecutor, and that's part of like the thing I love about having this dynamic and dialogue. You can get different perspectives, and you can have them vetted and argued, and you can make that assessment yourself. But what's the saying? You put two lawyers in a room, you're going to get 5 different opinions. So,
and there are some lawyers I love normally who I think have had some bad takes on this one, and some people will think that of me. And I'm not calling anyone out, although I'll say I haven't yet been able to watch EDB stream, so I'm definitely not talking about her. I just haven't been able to see it yet. That's on my to-do list for this weekend. But it's...
Oh no, EDB, just like you, buddy. Like, there's people that have just, if they want to show up, they can show up. I try to manage who comes on the stream because the ADHD thing. She gave her take, we're giving ours.
Oh, and she's got an open invite. Like, if she showed up and was like, I want in, she'd be in. Like, that's
yeah. And that's fair, Saskia. I don't, like I said, you're gonna have a lot of lawyers on here.
The thing is, 400 people, like, they're allowed to do the survey, and 400 people is not enough to taint anybody. And they're not required to tell anybody, like, they're not required to tell anybody before they do the survey, right? That's not a requirement. You don't have to let the other people know before you do it. That's just not part of it. I don't see another way to do this interview that gets you a fairer interview. And I've been in this situation where the prosecution says, oh, they're doing something improper. And then if you don't do it, they're going to say, oh, they didn't do the thing that we prevented them from doing. Right. And that is
the whole process fair, not just part of it.
Yep.
And Armand, to your point, EDB and Lawyer had the same take. No, they had different takes. EDB said that the questions were out of bounds and was focusing on the first part of the non-dissemination. Peter said that he agreed the questions could be asked, but he wouldn't have asked those questions. So different takes, like I said, different people. And Andrea Burkhart, Andrea is a criminal defense attorney, just like Ian. So you're going to get different takes from former prosecutors, former defense attorneys. You're going to get these takes that are different. You just got to process it how you do. So
I also just know that if I was charged with something in the US, Andrea's the person I'd call. Like, I mean, assuming she was able to practice in that jurisdiction.
Close second. Like if I was in Washington, yeah, she's calling her in 2.2 seconds. Yeah.
So
without a question. So, let's see. I wanted to listen to the beginning of this and we'll fast forward towards the end.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial, okay? And our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory.
So why did you draft the order with a carve out that let them restate the concerns? That's my question.
And the other thing is, if that's the concern, then what are we doing about the fact that the prosecution said all of these things already in public where everyone could hear? Like, if that...
Yeah.
Like, aren't we already there yet, if that's the concern?
That's one of the points. I mean, because again, like I go back to this, and I'm gonna share this again because people can disagree because we've been doing this for a little bit. So if I do that, I do this, and I try to go back to here. What are we talking about? What are we talking about? Talk about this. 2, this is the exception. This is what attorneys by this order are allowed to do. Attorneys involved in this case and their agents, as outlined in paragraph 1, which is all of these people. Everybody may make extrajudicial statements, written or oral, concerning the following. B, information contained in the public record, which is the PC affidavit. PC affidavit. So that's there.
I mean, what I haven't heard from the prosecutor on this one is, I mean, they gave an impression of what they would have liked to have seen the prosecution's survey look like. And the thing is, it's such a ridiculous suggestion because it's basically like saying, I would have really liked to see the defense run this case with one hand tied behind their back. I would like to see the defense do a shitty job of defending, because that's what their suggestion comes down to. I want to see the defense do a shitty job. Defense, why aren't you doing a shitty job? Do the shitty job. And I'm like, well, they're not doing that because that would suck. Like, that's not justice.
Yeah, I told you before, chat would be mad at us.
That is fair. And chat can be mad. Sometimes people are wrong.
You got to see the other side. If you don't see the other side, you can't understand the whole argument. So, but he goes on. Again, these are things. Why draft the order the way you did? Why? It's your order, Judge. It's your order.
It could be
the order's drafted the way it is because
okay,
they can't prevent them from talking about, like, there is a limit, right? So he's got a right to defend himself, and there's already an issue with, like, the prosecution got to dump all of this at the beginning, and defense hasn't been able to respond even They're just like, but all defense has asked for is said, we just want to stop the prosecution from doing what they're doing, which, I mean, like the media leaks were ugly, and
there was too much reporting of leaks from the state. That bothered the hell out of me. That bothered me a lot. And Maggie May, no. Not mad at the argument, frustrated that I'm not calling you or anyone in the chat stupid. I have said repeatedly that I can completely understand how people reach the contrary position. I 100% get it.
We argue about this stuff like lawyers, and lawyers are used to arguing.
I will call Ian an idiot. I will never call anyone in the chat an idiot. I call Ian an idiot because he's like a brother from another mother. And it's just two brothers fighting.
And the thing is we've had, like, we'll get into disputes where we're arguing about like Google Maps or whatever, and we know that it's just a legal dispute, right? And we argue like that because we're talking, like I'm talking to Rob and so forth. I'm not trying to, I hope nobody in the chat takes it as like I'm trying to attack them. I'm just passionate about sort of where I come from on this one. And to me, this is a very important issue because this is fundamental to, to rights and to very critical issues. One of the things I sort of always ask people to consider is, what if he didn't do it? And more to the point, what if you didn't do it, but you were in his shoes right now?
Yep.
Because, how would you defend yourself if the prosecution put all of this information out and let's say it turned out that none of this was true?
Yep.
That all of this was BS. How would you defend yourself? How would you be in a position to get back onto an even footing after all of this?
Yep. How do you make it fair again when it feels like it was made unfair to begin with? And Maggie May, sorry.
Oh,
I just want, you're right. I will take ownership of that. That was me defending the process and being frustrated people who don't understand the process. The idea that the defendant in cases in the US, the defendant has the right to counsel, especially when the state is seeking to literally execute this person. The state, the body politic, the government who creates the laws is using those laws and inflicting justice and retribution by depriving this person of their life physically, actually injecting them and taking away their life. That puts them at a very, very high standard. And because we as a body politic recognize that deprivation of life is the highest of things that the state can ask, we bestow upon these people who were accused the absolute right to counsel. And we task those attorneys that are appointed as counsel to zealously advocate for their clients. What was it? John Quincy Adams, who represented the British soldiers at the massacre in Boston Massacre? Boston Massacre. And he represented Redcoat officers, Revolutionary War time. He represented them even though he was one of the founding fathers. And he represented them and sought their acquittal because that's how much he believed in the right to have competent counsel represent even the worst of us. So, yeah, I apologize for the rhetoric. I didn't mean the rhetoric, and I didn't mean that literally, that people should get out of the country. What I meant is that please understand that this law is so ingrained in the judicial process that we have to respect it. And if we don't, it's a very, very rapid, slippery slope. Yeah, John Adams, not Quincy. Yeah, you're right. Quincy, yep, John Adams. Thank you.
And the other thing is, defense lawyers are so much fighting an uphill battle, like all the time. And I think most people don't really realize just how uphill it is a lot of the time, because like, you know, we get random threats, we get all sorts of things, right? Nobody, you go to a party and you say you're a defense lawyer, you're gonna get crap, right? Somebody's gonna, you know, take a shot at you, like, you know, not like throw a punch, but somebody's going to be aggressive. And it's just like, but it is important. And the I think that this case really needs to you know, he's got to be given a fair shot, and he's got to be able to make the argument. And like, the prosecution isn't going to turn around later and say, oh, well, it's not a big deal, like, they couldn't ask those questions, so we're going to cut them a break and say, you know, we'll assume that there's some bias because, you know, it's like, no, they have to be specific, because to the degree that they're not, they're gonna get, you know, they're gonna get stabbed for it. I can tell you quite literally, I ran a trial not that long ago where the prosecution successfully managed to keep my expert from testifying, and then argued that there was no expert evidence.
Yep.
And it's like, well, and the thing is there's nothing inherently wrong with that. But, you know, it's like, you have to try to get the expert in, because otherwise it's, yeah, you just
gotta do it.
Yep. So they need this evidence. They need this information in.
Yep. And no, I don't have rose-colored glasses. I know they look pretty. No, I understand the process isn't fair. Doesn't mean I shouldn't keep advocating for it to be more fair. That's what I'm arguing. So let me catch up on some of these, and then we'll get back to some of this because I don't want to miss too much. Kimberly Stovall, I was shocked at first. Now I realize how often polls are used. Also, I agree when Anne explained it was public, it was over. Was this about Judge's ego being bruised over the letter? I don't think so. I think that
it was a little bit about that, because you can see the judge is upset about it.
He was. I think that a lot of this was, look, when people file stuff, just like text message, you ever have a text message battle with somebody or an argument with somebody?
No, I've never had an argument with anybody.
No, not at all on Twitter. Never, Ian. You would never.
Yeah, no, that's totally not how I roll.
But there's a whole lot that's just being lost in between the words. Like, if you could see the person face to face and make the argument to their face, you might actually perceive what they were saying rather than what you were reading it as.
But if something's lost between words, you can't blame Google Maps.
Oh, I hate you so much. So, but what I mean is that, like, these filings, what ends up happening, and even I made the comment to a friend of mine about this hearing, was this hearing starts really contentious, right? They are going at each other because there's been all these filings. There's been words that have been written on paper, and they have all perceived what they are reading. They're perceiving the words as they're reading them, not as they're written. So everyone comes into this hearing, judge, prosecutor, defense attorney, all of them on like level 10 as far as emotions are concerned. By the end of the hearing, they're all like down to level 3. Like, they're all kind of chilled out a bit.
I think the judge is more like level 8 by the end of the hearing.
At the very end, he's a little more chill. Prosecutor is still at like a 6. Defense attorney, she's like a 3 to a 6, something like that. But the temper is cool, because what was previously being exchanged in written form is now being argued in person. And you can see the person and see how they're perceiving what you're arguing.
Well, this is another good reason not to have emergency filings, because a lot of that, I can tell you, you can take a lot of the emotion out of the out of your filings by write the filing, wait like 4 or 5 days,
write it and revise
and
it,
then rewrite it or just edit it, because there's a lot of times when you go back and you're like, oh, hey, I was real spicy there.
Yeah. I had one of those.
I need to be less spicy on that one.
I had one of those this week with an email. Should have like sat on it.
I mean, when I went to the Supreme Court, I can tell you, I wrote my factum and I did a lot of rewriting because initially I was coming in hot. I was angry. And then after you get that out, and I find I do this a lot. Like I'll write my initial draft, and my initial draft, I get to be as spicy as I want. And then I come back to it and I'm like, I'm at a 10. I need to be at like a 6.5. There is a sweet spot for like snark in factum writing. You want to, where you've earned it, where you've done enough to say that you have, to show that you're right. You want to have a little bit of contempt for the other position, not the other lawyer, but their position, but not so much that it grates. You just want to be like, you want to convey that their position is BS, right? So this was exhibited most very skillfully in the movie My Cousin Vinny, when he stands up to make his address, and his address goes along the lines of, everything that other guy just said is bullshit.
Yeah, I mean,
that's first draft.
Yeah, and it helps to have lawyers in the office that where my law partner will write something and she'll like call me out and be like, "Hey, Rob, can you read this?" And I read it. I'm like, "You sent this yet?" No. All right, let me revise it, and then you and I can chat.
Let me pull a couple of peppers out of this one.
Yeah, just a bit. Virginia Tracy, it's paramount that defense be allowed to do its very best to demonstrate the defendant just might be innocent. It's their job. Yep. Purple AJ, reverse is happening in Richard Allen, Indiana. Yeah, I've seen some of that stuff. I don't know enough to give full opinions on it, but some of what I've seen has been kind of concerning.
I've only seen a little bit. I need to do more digging, but he's been denied money for an expert. That's tough.
It is.
I mean, this is the thing, is the best place to be for litigation purposes is personally wealthy, where you have an unlimited budget. Like if Bill Gates gets charged with something, he's got 10 lawyers working on it. So like nobody's losing any sleep because everybody's coming in rested. They've had lots of time to do all this. And what is it? And they're also able to spend like infinite time researching, and they need an expert. They got one. In fact, they got 3, right? And
they can pick, and they can have a consulting expert they don't have to disclose the opinions on. That's a trick. Yeah, that's a trade that people don't really realize.
They hire the consulting expert to read all the opinions, and then the consulting expert recommends expert Y, who they already know what their opinion is. So, and they bring consulting expert into the fold, so it's protected by privilege. That's a rich person move. Yeah, it happens a lot. The girl with the animals, nothing better than spending Friday night here. Thank you for being here, Robin Shermantine. Should the questions have been so explicit? I don't know. Either. I think the answer to that is yes.
I want to hear from the expert. That's my opinion.
Yeah, and the thing is that the expert, I'm pretty sure what the expert did is just, I mean, you know what I would be doing if I was the expert? I'd be going on like Reddit to see like, and I'd probably be going to like the local area subreddit, like, you know, Idaho or even Lotta County, and being like, what have people been raising in the discussions about this? And then taking some of those statements and, you know, using that. And looking at things and statements like, what did the prosecution say? What have they said about these things? Okay, I'm going to use those statements. I would be very cautious about picking statements that I didn't have a defined source for, that are either statements that I see circulating already in public or statements that have directly come from the other side. That's where I would be looking to fish. If I was, you know,
like the PC affidavit that was the questions.
Yep. That and just anything that I already see circulating in the community to say like, is this a one-off or is this deep?
Yeah. And I feel like that was the safest of the fair game that they could have gone into. Canonical Heat, and always appreciate the mods. They are amazing. The mods are phenomenal. Guys, please thank the mods. Thank them for being here, for keeping the chat on topic, even when we cover controversial stuff like this. I appreciate the hell out of them. Thank you very much. And for those of you watching, please consider hitting that little like button. It's very easy, and subscribe. Mama Smith, thank you for getting a membership. Nanner, not going to say his name out loud because he's sleeping. Where's the sock? Good boy, and find the sock. Don't do that. You swallowed the last one. The Chugi Show. Mom does a lot of cooking and can't explain tart to me. Okay. Lucifer, Puppy Cam is life. Puppy Cam is there. I heart the Leo Cam.
I need to get a Zora Cam.
Mary became a new member. Harry Potter's beard became a new member. Ryan Man YYC, it's official. I'm out of the hospital. Yay. Ryan Man YYC, an always present person in the chat. Thank you.
Also, Rain Man. I keep getting it wrong too, but it's Rain Man.
Rain Man. Rain Man YYC. Thank you. And congrats on being out of the damn hospital. Sir Black. I've avoided this case. The questions are a problem for me. That's fair. Rain Man YYC, thank you for gifting memberships. Much appreciated. Hope you are on a fast track to recovery after getting out of the hospital. Ballet Girl, thanks for becoming a member. Nikki Lewis, State just put details out in the hearing too. That was part of my problem as well. I explained that earlier. SF, Taylor should have read the PC affidavit in court on Thursday. She kind of could have. I think she
the thing is
missed an opportunity.
She doesn't want to do that, right? She's trying to. She wanted to reach specifically 400 people, because I can guarantee you, in that jurisdiction, more than 400 people watched that hearing.
Yeah,
live.
Yeah. Or saw recaps of it, like this one.
Or saw recaps of it. So, yeah, and Harmony, I try to answer some questions as I see them, but we can't see everything. Chat flies.
There's 2,500 of you here. I can't see all of you at the same time. And to the point that people were watching this live streamed and the commentary, I have no problem doing what I'm doing, giving commentary on this hearing, because I'm giving a perspective of, I want you guys to recall back to when I was talking about the bias thing and how to analyze your own.
Also, First Amendment, yo.
Yeah. I think it's important.
I feel like the First Amendment needs a gang sign.
I don't think it should. Interesting, though. Canonical Heat. If you do all the things, like, subscribe, tap that cute bell, good fortune will follow. And Booze. Did I mention Booze? Maybe a puppy. There's a puppy on the screen right now. Tracy Fagan. I think we have had this conversation before. Toothbrush time. She wasn't there. She wasn't even close.
No, this is not toothbrush time.
That was not toothbrush time. This is soft.
This is zealous advocacy. And if he made her pack her toothbrush over this, two things. One, he's off the case.
Oh yeah.
And two, it's going to be a bigger headache for him than it will for her. Honestly, if I was Ann Taylor doing this stuff she's done thus far, and the judge sent me to jail over it, I'm like, fuck yes. And
for your client.
I'm calling one of my associates to say, hey, could you pass along to our client, the one from today, that I think things went well today. Tell him I'll explain as soon as I can, but things went well today. Things are looking very good for where we sit. So yeah, I would not be upset if that happened to me. And once in my career, I have told my wife, if I'm not home when you get to home, it's because I'm in a cell.
I haven't had to have that conversation with Mischief yet.
Yeah, it was a fun conversation.
It was always my law partner that I had to tell when I was going to court, like, BT dub, if I'm not back, like, call the jail.
I had a lawyer on standby to basically be like, are you free this afternoon? And they're like, why? I'm like, because I might go to jail. They're like, okay. I'm like, I'm good for, like, do you need me to put money down in advance, or do you know I'm good for it? And they're like, I know you're good for it. I'm like, cool. I might need, like, bail. I might need you to argue for my release. And they're like, okay, I'll need the story later, but yeah.
Yep. Lost in the crowd of 3, but couldn't the asking these specific questions, can't they have a boomerang effect and fuel more supposition? They certainly could if the prosecution decides to bring a whole motion and have it argued in public on those questions.
The prosecution could have had this argued in private.
Am I the only one that lost Ian, or did we all lose Ian?
Can you hear me now?
I can hear you now.
Okay, good.
I thought I boomered it. I really thought I screwed that up.
No,
Because last time that I made the accusation that I lost somebody, I did not lose them. I was wrong.
So I got a new I got a shock mount for my thing. So hopefully the keyboard typing is less. The problem is that now it causes my mic cable to fall out at times. So what I need to do is get some string and like tie it in. So that'll be occurring.
That's complicated. Danny, the insurance girl. $20 super chat. I'm sorry I didn't pull this up earlier. I hope you're still here. Happy tears this morning. Got my graduation email notification and invitation. Certainly celebrating right now. More hard work to follow, but I'm getting there. Can't share with people I want to, so I am sharing here. Danny, the insurance girl, congratulations on your graduation.
Absolutely.
Cheers to you.
I am out of scotch. I need to pour another scotch for this.
Yeah. I anyone that's having happy tears right now for graduation notifications and sharing it here, cheers. Way to go. Absolutely awesome.
You, Danny, and your achievement.
Indeed. 20th Century Fox, Andrea twice in one day. I love it. I love that she was able to join. Nance 70 memberships. Go ahead, Ian.
She's one of the people who anytime she comments on something, you know she's like really done the homework.
Yeah.
And
she does.
And if I said something and Andrea says something different, I'm like, oh crap, I'm wrong. Because that's how that works.
I immediately get that concern of, am I right? Am I right?
One day I might say something and Andrea says something different and I'm right, but I don't see that happening anytime soon.
Yeah. Tammy Fayette, Andrea, are you from Philly? I'm a Philly girl. We had a conversation earlier. I think she's a Philly fan. I don't know if she's originally from Philly. Gretchen Call, setting in for an interesting night after the passing of my grandmother earlier this week. Thanks for the slice of normality. The passing of any individual is complicated. I'm sorry to hear that your grandmother passed. I'm hoping that the conversation and the debate and the spirited nature of the discussion is enough to distract from what must be a very difficult moment in your life. Remember the good times. Please do. It's going to be a process. But like I said, you can talk to them. Keep on chatting. They're still there. Rosebud. I think Judge is my new favorite judge. I have questions. A lot of them. Twigs, thank you for the super sticker. Canonical Heat, thank you for the gifted memberships. 20 gifted memberships. P. Fox. Rob, thoughts on Judge? He's no Judge Carroll. The Judge makes a comment later in the hearing, and he says, it was almost 5 o'clock. What was I supposed to do? That kind of struck me a little bit, because for those of you, and this is a good kind of,
I may have a different take on this one. I want to hear where you're going with it.
For those of you who remember Judge Carroll in the Maya case, Judge Carroll was reading those motions over the weekend and making rulings over the weekend. And he was actually inviting additional filings over the weekend and was reading them. I don't think that that's to be expected of every judge. I will say that Judge Carroll, in my opinion, he set himself apart in that regard. He went well beyond what was expected of him in his judicial capacity. I don't fault the judge for coming up to 5 o'clock and that being the cutoff. my frustration is when that's the cutoff, you say,
this is also jurisdiction dependent because sometimes they can't do these things without like the clerk. And clerk ain't there on the weekend.
That's true.
So
when you're approaching 5 o'clock, I think the right call would have been defense has until Monday at 4 o'clock to brief the issue.
The problem is he's being told that this is like some sort of emergency. It's tough. Like it's tough to say what he would have done there on that one.
It's hard.
Like, so
it's a question. It's an open question. Sarah Bellum, thanks for becoming a member. Lindsay, question: if 1% isn't enough to potentially taint a jury pool, then how is it enough to show that there's too much prejudice to proceed in the venue?
1% wouldn't do it.
And well, this is a question on statistical significance. It depends on who that 1% was. Something can be statistically significant to show something, to show a disposition, but not.
If they show bias in 1%, they're not getting a change of venue.
No, but if they use a 1% sampling and the sampling is broad enough.
Oh, if it's a sample and that sample gets that.
You're talking about statistical significance.
Yes.
You're not talking about 1% of the population. You're talking about a statistical sampling of 1%.
So can I diverge a bit into statistics?
Ooh, yes. Briefly, Ian.
Okay, so let's talk about statistics because statistics is one of the most important topics in your life if you want to understand the world around you. Because for the vast majority of things, we cannot survey the entire population. Like, how many people are... Well, I mean, let's consider a really common example. Does this heart medication make you more likely to live? You can't survey everybody. You can survey some of the people. And so what statistics does is you take a sample out of that, and there's complicated math. I used to be able to do the math. I can't do the math now, but I used to be able to do the math where you can determine how much power that sample gives you to extrapolate to the larger pool. And especially there's complicated math to determine if you have a sample, like you take two samples, let's imagine you have 2 bags of beads, right? And you reach your hand into bag of beads 1 and it comes out and it's got 17 white beads and 30 black beads. And you reach your hand into bag of beads number 2 and it comes up with 37 black beads and 6 white beads. Can we determine that these bags are likely different in their composition of white versus black beads? We get into math about how big is the bag? How much is our sample? How much is the difference? And so we're actually very good at determining whether or not there's a difference between 2 pools. And that's what they're looking to do here, is they're looking to say that Latah County has 75% of the people have heard of this. But nearby, I forget which counties they said it was. So neighboring county has, our sample came up with 60%. Is that actually a difference? And so they can run the stats and say this is a statistically significant difference. And so based on that, we can conclude that there is actually a fairer jurisdiction. That's sort of what they're trying to do here. And it's an entirely reasonable thing to do. And we do this all the time. Virtually none of the important decisions in your life are made on a 100% sample because we just can't do 100% samples of anything. It's not practical. And in many cases, it's just not possible. So that's how life works. I can tell you that decisions on your health, decisions on millions of dollars, decisions on all sorts of things are done on samples all the time. As a society, we're really, really good at this because it is so important. And so anytime somebody says, oh, they only looked at, like, small sample sizes can be a problem, but they usually aren't. 400 is a pretty big sample, actually. So it's not like they asked like 6 people or something. This is not a sample size problem.
No, it's not. I can't say his name right now because he's looking at me from behind.
Sorry, whose name?
The individual at the bottom of the screen. I'm not going to do that. I wasn't going to.
You know, I'm just causing trouble, right?
I know that was a good trap. It was a good attempt. Was it a good attempt? Elizabeth Ramos, opinions on defense sabotage. They want the trial out of this county. That's not why they did it. I'm telling you right now, the self-sabotage argument, because the judge finds that effort just denied, and now they've tainted the jury pool where their defendant's going to be tried. That's not there.
It's not sabotage to the extent that there was any sabotage. You could point to the prosecution on this one, but I don't think you can point to the defense.
Knit Therapy, thank you for bringing a different perspective to this hearing. I thought we might, and I just wanted people to see. It's not to discredit anyone else who has a different opinion. It's to see the other side. Megan Brogdon, so prosecution strikes into the issue. They did indeed. Anna, I'm more concerned over who are these people that answer a call from a number they don't know and answer questions from an unidentified person. Anyone that does that is a psycho and can't be trusted. Well, I'm not going to disparage people that voluntarily participate in polling. I will say that I send those people straight to voicemail.
This is actually a problem with polling, is that people are a lot more reluctant to answer their phones at all.
Yep.
And also a lot more reluctant to provide this kind of information. So
yep.
I get it.
While I think the defense was trying to pull some shady shit, I personally don't think it will make any difference in the outcome of the trial. I don't think so either. I just wanted to see kind of fair play. SF, EDB's chat knew almost every single question asked in that survey. Therefore, all those questions were already in the public view. That was kind of my take on it as well. Mary Coppola, 13. Bottom line for me, throughout any trial that is aired or we talk about, is the judges. We have seen judges who are in control of their courts and their decisions, and we have seen judges who do the opposite. You see not just the judges, you see the litigants, because the judges respond to the litigants. So it's kind of, you have to view every court case as a dynamic between 3 or more people: prosecution, defense, judge, plaintiff, defense, judge. It's a dynamic that gets created over a period of time. Halen Mouse, wasn't it the female judge who made the first gag? It was, and then this judge tried to revise it, and now we have where we are. Outside the box, it's so interesting to listen to this after listening to EDB last night. I'm seeing a defense prosecutor mindset divide. That's why I'm talking about it. Honestly, great to parse both sides. Reasonable minds can differ. Yes, that's why I wanted to talk about it tonight. I wanted to talk about this topic because I wanted people to see the other side. Tiggy girl, why is Kohberger getting a better defense than Daybell when both are in Idaho penalty cases? Brian has a law team and surveys when Chad does not. I don't know. Chad Daybell, is that? I thought they took the capital off of that case.
I don't think so.
Case?
Kurt was saying that it was still a capital case. So
interesting.
I
don't know. Different facts, different scenario, less defense, fewer defenses. I don't know. Kathy Sawyer, love catching a rare live stream. Thank you very much, Kathy. Canonical Heat, if you haven't liked yet, or why, maybe a like for the Leo cam. Yeah, Leo's hanging out down there. Oh, shit, I said his name. He's still quiet. Melissa Smith, Leo Lions Bed Sofa King Cute. He's a cutie. Crazy Cat Queen, I hearts. I'm able now to understand the concerns of both sides. Thanks to y'all in EDB. I didn't realize what could be considered public info. We're going to have different opinions. When people say that you just have the same opinions as everybody else, no, we will starkly contrast where we can or where we do. Baby Gator, Bust stop.
I mean, the thing is a lot of the time we have the same opinion because it's the same law. But occasionally we have different opinions because it's like, yeah, this is, this is more debatable.
Yeah. And the fact of the matter is you could put us in a courtroom and we'd probably argue pretty freaking emphatically in opposite directions and still be able to walk out of there and have a beer or scotch or whatever. Baby Gator, I was originally with EDB and lawyer, but after hearing the dissemination order and listening to this hearing the third time, I'm starting to change my mind. It's about information and how it's delivered. Thank you, Baby Gator. Bureauin, hard to listen due to those gigantic puppy paws. Yeah, they're hidden right now, but yeah. Sandy, thank you for the gifted memberships. Why are you doing it? You're a mod. Laura Christine, thank you for gifted memberships. Rosebud, thank you for gifted memberships. Kimberly Stovall, didn't Anne say that she sat on it and her ex parte bit her? That's a pun that I botched. Didn't Anne say that she sat on it and her ex parte bit her? Maybe. I don't know. Shall see. Motion for puppy cam to happen more often. It's just out of town. He's with me. Patty R, thank you to the mods. Thank you to the mods indeed. Jessica Reloaded, Leo greater than Rob. Fair. Also, still waiting for you to guest on a stream with me. Jessica, been a while. Glad to see you in the chat. Thanks for popping up. Very much appreciate it. And yeah, I'm around. I'm doing a Lego building stream with MLS Law tomorrow. So that'll be fun. I haven't done one of those. I haven't built Legos in a while.
I haven't built Legos in forever.
It's the house from Up. So I'm excited about that. Kate, can we go back to the fact the state agreed the information in the questions was not factual? They didn't say which questions, though. Golden Girl, thanks for gifting law memberships. Aaron Evans, I was sitting in EDB's stream, who I usually agree with, thinking all what y'all have been saying, wondering if I'm just nuts. Thank you for showing me I'm not crazy. You're not. And people that agreed with EDB aren't crazy either. Angela Whitaker.
Yeah, I wouldn't use agreeing with me as the barometer for not crazy.
That's fair. Me too. Same. But you're allowed to have different thoughts about this damn thing. You really are.
Just so long as you recognize that I am right in all circumstances.
Sure. It's just like Ian's hypotheticals are the best hypotheticals.
That is also true.
I mean, objectively, that actually might be true. Angela Whitaker, it's great to hear a different take on this after watching this via EDB and Lawyer and now hearing your point of view. It makes me rethink my position. The point is, every one of you should be armed with analytical thought process. And when you walk into a consideration of a hearing, don't just listen to the people on the screen. Hell, disagree with me all you want. Listen to what's being said. Listen to the arguments. Vet them for yourself. Think why they're being made. Think what's not being said. It's really important. Elise Charlene, fine art. Leo, so cute. He's dreaming of running. His feet are twitching as he is running or chasing something. I don't know. Something. Crazy Cat Queen. 2 things I don't like about Judge Carroll. He's a gator, and he hasn't hammered J Hatch yet. Yeah.
He's a gator?
He's a Florida gator.
I thought they meant like an alligator, and I was like,
no, sports ball.
Yeah, no, that's unfortunate.
Rosebud 26, LOL. I meant his name is my new favorite. Judge. Sorry, I forgot to add the previous super chat. Yep, that's fair. Judge is a pretty badass name. Larry Larrett, thanks for becoming a member. Blessed Mommy, you've of 4. Blessed Mommy of 4. Thanks for becoming a member. Bop it. Second, the motion for Leo Cam. I can try, guys. I really will. It's very rare that he stays that still. And when I disappeared the other time, it wasn't because of a bathroom. It was because I smelled something burning downstairs, because I have been taking his elk antler and kind of boiling it in chicken broth and then baking it, like to just reinvigorate flavor. I took the antler out and I forgot the stove. So I started smelling like the burning of the bottom of the pan, which is why I had to bump out of here, which is why Leo almost chased me. Weird. Pisces, if I heard it in the media, I would just ignore the statements. But if I got a call, I would feel the info is correct and not just the media talking suspicions. That I can see that argument, but also people call about all kinds of shit. They really do.
I'm calling about your car's extended warranty.
I was going to say that.
Do you take
I was
that
gonna
as
say,
correct?
your
Or
student loan, your taxes. Those are the other ones.
yeah, I'm just saying, like, don't take it as correct just because someone's on the phone, because most of the phone calls I get and the texts I get are scams these days.
Yep. All right, let me pull this back up. We'll listen a little bit more, and we'll go to the Diddy stuff.
Okay, and that I'm just surprised that both of you didn't come together and say, you know, there are certain things that we probably shouldn't put into the public on a telephone call. I mean, it really concerns me, and that's why I did what I did that Friday. Now I'm being accused of violating a due process, which is a whole big issue for me.
I can understand that would not be taken away. I have to represent my client to the best of my ability. And the reason for that,
Oh, the lawyer apologies.
Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process. But since it came up and since that feels like the elephant in the room right now, I think maybe we should just go ahead and address that.
Sure.
And that was my motion. And I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into, and it was a one-sided
I'm not locked into anything. My order didn't say it was permanent.
Maybe
and it told you that I was going to have a hearing.
Maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday.
Yeah, that wasn't accidental.
Which is why when you receive the motion at 4:30 on a Friday and you read it, you literally say, you say, what would happen if I don't enter an order right this moment? Now, the motion, I believe, alluded to the fact that the survey for Latah County was already done.
Yeah.
With
So
no
what
indication,
happens? Nothing.
no indication that it was continuing, or to what extent it was continuing, or how many people were being contacted within a 1, 2, or 3 day period. So 4:30, if I pick up a motion, I am being very restrained in what I am doing without having a full response from the other side. And I mean full response.
At least giving them a chance to respond. And
this is where I get frustrated with the judge. And where
I mean, he could have said, like, hey, listen, can I get a response on, like, by Monday?
Monday. That's what I would have done. I want Monday.
Yeah, and it's Easter weekend, so.
Now, it doesn't even reflect.
Zora knows everybody loves
just
her.
when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday.
This is the wrong opinion. Now, that's my opinion, that this is the wrong opinion, which is fair. Judge was erring on the side of caution, which I think was the right thing to do in order to protect the case. The reason why I think that's the wrong opinion is the erring on the side of caution is allowing the other side to fully respond.
Yep.
That's the erring on the side of caution. Jumping into making a decision, whether it's temporary or otherwise, hearing one side's argument and the other side's partial argument is not being cautious. That's jumping. That's doing something. It's being proactive. Now, the idea that that was to protect the case.
It also threatens the case if you mess
also
with the
threatens
defense's survey.
Correct. It also threatens it. So there are two sides of this coin. Now, the judge chose one of those sides. I think wrong. Other people think right. I'm going to tell you that you're going to find that split pretty consistent among lawyers. It gives me great pause to think about the opposing side hitting me with a full-fledged motion that's briefed, or a full-fledged motion with exhibits and citing case law that I see for the first time at 12 o'clock that day, and dropping what I am doing in every other case, which might have deadlines I have to file by the end of the day, like summary judgment motions or motions in limine or other things that are really important. Dropping everything I am doing to try and prevent the court from entering an ex parte order. Ex parte being without the participation of the other side. So I have the very opposite opinion here, that caution would have been, I want full briefs by Monday. Or if the judge had done that, the judge would have said, you know, if it's a temporary order, that temporary order expires at 4 o'clock on Monday, by which time I will have a brief from the other side and I can make a broader temporary ruling, right? So pause over the weekend, give me that brief on Monday, let me reconsider the pause. Then it's 2 days, not a longer period of time. So I was concerned by how this took place.
I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an
That's what I
objection
got.
the minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the material.
I had a half an hour.
Yep. I mean, the thing is he didn't have half an hour. He had more time if he was willing to take more time. It just required him saying, I'm not giving you what you want, like right away. Like, if you wanted an answer faster, you should have given me more time in the day. And maybe not Friday.
I did not like that. I did not like that at all. Oh no, Taylor's not only available Thursdays. She said she would have. People are gonna hate what I'm saying. Blah blah blah. Like he said he had a half hour, so he had a half hour to make one of two decisions. One, decide based on what you've seen for the prosecution and limited response of defense, which was filed same day. One, the fact that these two filings came in on the same day is itself shocking to me. I don't know that I've seen a defense attorney get up and file something that quickly. Like, that's freaking
Oh, that's
amazing.
drop everything.
That's drop everything. This is a big issue. I am dropping everything and I'm filing something. I can't get everything, but I have to file something, which I think was it was a mistake by Ann Taylor personally. Because I think if he hadn't received a response and he had entered an order, the scrutiny that he is trying to pass off would have been a lot more warranted.
Christ, if the fire alarm goes off, it's lucky if it gets a response same day.
That were attached to the motion that the state filed, and I had very little information. But it seemed like
Then you deny the motion.
I had very little information, but it seemed like. This is worse the fourth time I've heard of the hearing.
real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about.
And Taylor, I have a frustration.
This is where you got to push back.
I have a frustration with you because he just said there turns out there are concerns and legitimate concerns. This is where you bring your fucking expert and you
This
say,
is where you say you haven't heard from the expert yet.
yeah, and you put them on the stand. This is where you say immediately, I'm sorry, Judge, you just used the word legitimate concerns. Let me explain to you why that should not have been.
Well, and you haven't yet allowed us to address, like,
Any
you're
of
assuming
them.
these concerns are legitimate, but you haven't actually let us present our, our case as to why they're not legitimate.
This is frustrating. I think that letter, the letter she responded with, while one, impressive AF, right? People in the chat are making the comment, well, the state told her they were going to do something. You don't know what they're going to put in a filing until you read the fucking filing.
Oh yeah, you can't pre-respond to it.
You have no clue, because I will tell you, I will have conversations with counsel and they're like, I don't like this issue. Then I'll read what they file and I'm like, are you fucking kidding me?
Also, the number of times I've had counsel threaten to file something
and not
that they never actually file is like always, I'm going to file for sanctions. No, you won't. Like,
So I think Ann Taylor, while it was a remarkable feat for her to put that letter together, the judge hangs on that letter.
I mean, she couldn't have known that he was going to do that. I don't think.
I know.
But he basically says you were able to get a letter together, so you were able to respond.
That's the point.
And if she had done nothing, then she could say, well, no, I wasn't even able to get a letter in.
Well, and so do the math here. So the state finds out the issues there. They have a conversation with counsel on Thursday. The state proposes a joint letter. One, do you think the state hasn't already started drafting a motion at that point? Two, this is the first conversation they have with counsel. So defense now says, we have an issue. State says, here's a joint letter. Defense says, nah, bro, not going to do it. You want to file something, file something. So defense goes back and says, are they really going to do it? They might do it. Shit, they might do it. So the defense is on alert, but they don't know. And then at noon, this motion, not a letter, full ass motion, case law cited with exhibits, gets filed at noon. And where Ann Taylor, I think, while I applaud the hell out of it, where I think she went wrong was she went off half-cocked. She was drafting a letter and she felt that she had to respond immediately. And she redrafted it to address some of the concern here and said, I will supplement later. Well, the judge sees that. And
always go full cocked, people.
Well, yeah. If you can.
You heard it from Rob.
The judge sees that and the judge says, well, you responded. Which I think is a disingenuous thing for the judge to say, because in her response, she says, I'm going to file a full response. And the judge goes, order. And the judge hangs it on like, I had 30 minutes. I had 30 minutes. And everyone in the chat that's saying exercise caution. You know what caution is? I go back to what I said. You know what caution is? Caution is not doing anything until you have the information in front of you to make the full decision, or at least a quicker decision or better decision. Emily, yeah, this part right here, this part, my gasted was flabbered. What the fuck? I wanted to hear the expert so bad because all those questions were audacious. They were like, did you read, hear, or know that there was a knife with
the other thing,
knife sheath with DNA? What if the answer was yes to 70% of those?
I mean, just from a practical perspective, if I'm paying for my expert to be on the call the whole day at like, anywhere from like $100 to $1,000 an hour, I am pressing for them to testify.
But I also know why Taylor held him back. You know too. You're not going to preview the testimony for the prosecution. Like, you're not going to preview that testimony and say, "Here, get a shot at him. This is what he's going to testify to." So I get it. I just didn't like. I didn't like a lot of this hearing, man.
What was done in the survey. So in the my order, I told you that I was going to set a hearing. So I don't know what your understanding is.
But you did something else too. You said no. You said stop. And then you said you were going to set a hearing. And I'm talking to you guys from the perspective of someone who's practiced in jurisdictions where when a motion like this gets filed, I get a notice from the judge's clerk within about an hour, because the judge's law clerk reads it first and can rush the judge and be like, "Judge, this is a problem. What do you want to do?" And the judge says, "Have opposing counsel get me a response by COB tomorrow," or hell, within 12 hours. I mean, the judge can kind of order anything. So
within reason.
I didn't like this. Like, give the other side some indication that you're going to rule. Plus, this motion hasn't been unsealed. We don't know if this motion actually requested emergency relief. That's one question I have.
Is with just the process. Okay, but I on Friday sent this hearing. So what are we doing today? Okay, I'm hearing you out. You had notice. I mean, really, that's what we're talking about. That's what the law. What is your understanding of due process?
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, "It seems that it may have violated the non-dissemination order." And so we're stopped from completing our.
There we are. That's why the judge did what he did. The non-dissemination order. Which, I'm going to say it again, it didn't violate it at all. Objectively false to say it violated it in any fashion. Because of Section 2B, the express carve out.
Or not to be.
Well, it was 2B. But it was not to be.
That is the question.
It was not the question, because the judge answered the question. Yeah. I was. This is where the judge starts to lose me, like, real fast.
Our comparative surveys right there when we're up against the deadline to get to our motion to change of venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Brian to be in a place where he can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean, this less than 2 weeks really has very, very little impact. Okay.
Okay, here's where the judge makes points, which are solid. There was the ability for the defense to say extend deadlines. And maybe it's this motion that doesn't bother me so much as it would be the case if it was a different motion. Let's say it was a different motion. Let's say it was a a subpoena for an appearance of somebody or a witness or a testing of a material, right? So this motion, yes, the judge can extend all the deadlines and say, we're going to push this out. Fair. You eliminate a lot of the prejudice. You do. I have a problem with the judge granting this hearing at all, to be honest, because it just lets the prosecution, well, take that 400-person survey and broadcast it to the whole world.
Yeah, I mean, they may have actually tainted the survey now.
Which is the fucking point. Like, if people don't,
That's the other thing I would have liked to hear from the expert on is, will the survey be irreparably damaged by having announced that it's being done and the questions that are on it so that people can recognize it? Because if so, then the prosecution has tanked the defense's case.
Fuck.
And that's an irreparable taint.
Now we get back to what I was talking about at the very, very beginning. When we're researching, let me give, here's an example. In domestic relations litigation, I use private investigators. I do. I have to. I use PIs. And I use them surreptitiously.
They
I don't
see
tell the
you
other
when
side.
you're cheating.
Kind of. I don't, or when you're misbehaving, like drinking around kids.
Yeah, they see you when you're smoking crack.
Yeah. I use PIs. If I had to pre-clear my PIs with the other side,
Not much point.
if I had to,
well, and same with like insurance defense, right? Like,
if I had to let them know I was using a PI, like if it was fair game for me in preparation for a motion, which is, this is a motion for change of venue. The judge has laid down a rule that says I can't disseminate shit, or the judge says that I can't invade private space. Let's say a judge says a no contact order, right? No person can come within 500 feet of the parties. That order's in place. I tell my PI, stay outside of 500 feet. I play within the rules, but I gather information in preparation of a motion. If I had to disclose what I was doing to make my argument, that doesn't seem right. Now, people are making the point about the jury. Like, these aren't juries. These aren't juries. You guys, you're missing the point that I'm making. Who just broadcast this to the whole world? Who just disclosed to the whole world that there was a PI investigating or there was a survey going on? Who just made known via contested motion and hearing that, hey, if you live in this jurisdiction and you want justice, you're going to get a call. Answer no. All the questions. I don't know about this. I don't know about that. I don't know about that.
yep.
And your work.
It does have an impact, Your Honor.
You don't even have a trial set. Come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial, so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state.
Nope. That's what she's telling the court. Her problem is the state just blew up her survey. Her problem isn't timing. Her problem is the filing of the motion. Her problem is the state just blew up her survey.
I mean, she needs her expert to say that. She can't really say that without her expert saying it first.
Yep. See that too. The sealing and unsealing in this fucking case I hate this case. I don't hate the case. It's a complicated case. But there has been a whole lot with this non-dissemination order where the drafting of this order is causing 9 million problems. And this is one of them.
I can't make the joke.
You can. You just don't have to.
That's inappropriate.
It's inappropriate. There you go. So you could make it. I'm not prohibiting you from making it, but you choose not to. EDB's point was, to be fair, the prosecution filed under seal until defense filed their motion to rescind publicly. That's what brought the survey to light in the first place. Yeah, I get that. And I kind of agree with this. I agree and don't agree. I don't know. I'm conflicted because the motion to rescind was about the judge's conduct, but the conduct was about the underlying motion. So I don't think you can file one publicly without making the other public too. So I think it should have been all under seal. I don't like the fact that this hearing is being held public at all. I don't like the order being entered. I don't like the hearing being public. I don't like a whole lot about this.
At this point, the only way to resolve everything is just switch it over to trial by combat.
Maybe not. Does the entire state of Idaho get to designate their champion? Because that'd be a problem.
They'll have to do it by vote.
They designate a bison.
In the time,
all right,
in the
bison,
deadline that I was already given.
Wait, what? You waited till they started talking intentionally. What?
I did not. I said, all right, bison, pistols at dawn.
You think you're going to take down a bison with a pistol? That's
a
funny.
big enough pistol, you bet.
Uh-huh. I don't think you got a big enough pistol for a bison.
More to the point, I think the bison is going to have real trouble operating the pistol.
Oh, God.
And meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state.
Oh, that's fucking bullshit.
She's not required to agree with the prosecution here.
I know that is such. This is where the judge really starts to lose me. The defense does not have to pre-clear their motion prep with the prosecution. They don't have to go through and come up with some consensus on what they need to do for the defense to lay the foundation for their motion to change venue, which the prosecution will oppose. Are you kidding me? But I get why the judge is doing this. The judge is going, you need to agree so that I don't have to make rulings that could be appealed. I understand that part. I get it.
I get it. I just don't like it.
Oh, it fundamentally fails to recognize the adversarial process between the defense and the state and the obligations they have to their respective clients, the prosecution to the state and the people, and the defense to the defendant and his rights. And that they are not going to see eye to eye. And they don't have to disclose everything to each other all the time.
About the survey.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things.
Which category? I hated that sentence.
I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk. We email each other. We talk to each other. But I don't need their permission every step of the way to prepare my case. Doing these surveys is not an—
Hold up. Wait a second. I've been reading judges for a long time. Ian, I'm going to rewind this for about 10 seconds. Look at the judge.
Oh, yeah.
But I cannot communicate with the state about how I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk. We email each other. We talk to each other. But I don't need their permission every step of the way to prepare my case. Doing these
That bothers me a little bit. I read that as it would have been less complicated if you did. Like, maybe in this instance you might have. Maybe I'm reading that wrong. I don't know. Maybe he's agreeing. I don't know.
surveys is not an anomaly. This is something that's done in these high-profile cases.
Well, apparently, Mr. Alden did not even see the non-dissemination order.
Why is that a problem, Judge? Tell me that's a problem. Because he also didn't see the file.
And you apparently did not give that to him. So this is...
She also didn't give him the file or anything from the file. So I go back to your order, the order you drafted. I'm sorry. I'm all the way into frustrated at this point. Like I said, fourth time hearing this hearing. Maybe that's why.
This is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case.
Fair point.
And now it's been injected at least to these 400 people without a permission of the court, without discussion with the state. I mean, that's troubles me. And then
without discussion with the state. This is the fundamental problem I have with this. This was preparatory information that she was gathering with an expert that was within. That expert is within they are in the trust tree. They are part of the defense team. They're in the tree of trust. You don't have to disclose that stuff. You just don't. The non-dissemination order is there to provide the guidelines. Non-dissemination order says you don't do this. Fine. As long as you don't do those things, you can continue to conduct your business and prepare for motions practice or do whatever you got to do. But the judge has already laid this lovely little framework, the rubric. The rubric. You stay within that. Do what you got to do. Actually, you're ethically obligated to do what you have to do, and you're actually ethically obligated not to pre-disclose or to share trial strategy with the other side. That's the other part. When the judge is sitting here saying you should have shared with the state, a lawyer for the defense has an ethical obligation to prevent the dissemination of information from their file or their strategy. You are required essentially to ranks. If you have a defense available to you, you reveal that when you are required to by rule.
And not a second sooner.
Yep. You don't jump the gun and go, by the way, I have this, because you know what that does? That gives the prosecution the ability to kind of go back and say, oh, well, I can rebut that. And if I couldn't then, I can now.
It's one of the important reasons why talking to the police is bad, because even if you only say good things, now they get to spend all their time prepping for all those good things you said, and they get to attack your argument.
Yep, which is why I think Ann Taylor didn't put the expert on. I'm not going to give them two cracks at that. Now, the challenge is, how are you going to refute what the judge is saying? Because the judge is just going off at this point.
And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process.
And now we are at the crux of the issue. I'm going to say something condescending. No, I'm not. I'm going to refrain. No, I'm going to say it.
No, you should say the thing, because it'll be funny for me to hear it.
Of all the people in the entire process who need to have a thick skin, it's the judge.
Of all the people in all the gin joints and all the... No?
Of all the people, it's just of all the people who have, I mean, remember Judge Carroll in the Maya Kowalski case, when the opposing attorneys were being fucking ridiculous. He got up, he left the bench, he somehow woosawed himself back into a state of calm and came back. Remember in the Darrow Brooks case, when the Judge Darrow got off the bench, did some magical woosaw, came back and was calm. It was never about them, ever. Because you big boy, you big girl, you wear your big boy, big girl pants. That's your fucking job. You put on the robe, that's your job. As a judge, you are going to be accused of violating people's rights. Part of the fucking job. Because you know who makes the orders and rulings? You do. You are the one that writes the rulings that says this person cannot put forward this defense, or this person is going away to jail. You are the one that says they can bring forth an alibi defense, or that the confession can or cannot come in. You are violating their rights every fucking day. All the time. So I'm sorry if you're offended. And what I was going to say was, Muffin,
there's a certain amount of life sucks. Maybe you should wear a helmet.
I don't. You cannot be this hands-on as a judge. And I mean hands-on. This judge is hands-on. This judge wants control over what gets out in the media. This judge wants control over what people say. This judge wants to be able to control who can appear, how they appear. This judge is very, very hands-on. You know what? You get down in the dirt, you're going to get dirty. You get down in the dirt, you make decisions. People are going to accuse you of doing things that were not proper.
It's true.
So, Judge, ask me how much I care if you're offended. I mean, really, I don't.
By the way, I posted something in the private chat as a palate cleanser.
We're gonna pull it up as a palate because I'm just about done. Like I
don't know if it's got audio, but if it does, it should be yakety sax.
You mean not copywritten? Like I'm not gonna get in trouble for it?
You don't need to play the audio, so just play it on mute.
Yeah. So that was my point with this, where when I'm looking at this, please recognize when you are seeing this hearing and you are seeing the lawyers argue and you're seeing the judge and you're seeing all these people involved, you're allowed to feel any number of ways. You're allowed to feel in favor of the prosecution, in favor of the defense. You're allowed to feel all of those things. You're allowed to think those thoughts and have those expressions. That's
so long as they're exactly the same thoughts and expressions I would have had.
Wouldn't go that far. But what I would say is that literally, guys, just take a second. Don't always. I get Kohberger's accused of doing some terrible things. I think the state's got if I was defense counsel, I'd be kind of afraid of the case. Let's just put it that way. And I agree with this. so much, Emily. Thank you for saying this because I've been shouting this from the beginning. Judge has to also recognize how much Ann Taylor has to preserve on this case to do her job. She has to do her job. This is her fucking ethical obligation. If she does not call foul where she sees foul, she is not doing her job. If she does not make the argument and that leads to prejudice to her client, which could lead to a death sentence, she has not done her job. Ann Taylor is doing, from what I have seen, a damn good job. Now, I wish she would have brought forth, I want the expert. But yeah. All right.
I mean, I want the expert, but that's largely because I'm greedy.
Yeah. We're going to a new topic because hell, I mean, I want to catch up on super chats on this one, then we'll go to a new topic. Lidachi, i.e. scary, I live alone, so no alibi for my behavior. It's there. Here for years. Why wouldn't defense share the info with their expert to literally preserve that? There is no way they had anything that we knew that was not in the public sphere. It was to
well, and also the expert probably doesn't need it
or want it.
Yeah, the expert is probably like, you know, the expert will tell them what information the expert needs. And the expert likely went, I don't need anything from you. I don't want anything from you. Do not give.
Oh, sorry, Celine. I just noticed that.
Did somebody wake up?
No, it was focused on his butt. No, so the other thing is the expert is basically sitting there going and saying, I have to put forth an argument to say that this is my consensus. This is my opinion that this jurisdiction is biased. And I know the prosecution is going to come back and say, well, I had access to all this information that would have swayed my opinion. Well, if I don't have access to that information, it makes it stronger. It's another reason. 20th Century Fox, robbed twice in one weekend. Love it. See you on MLS. Thank you. I'll be there at 9 p.m. tomorrow. Jeremy Morton, thank you so much for having Andrea on. Ian is my favorite, but Andrea is my more favorite. That you can reach that conclusion fairly. Crazy Cat Queen, should there be concern that by saying legitimate concern, judge shows bias towards prosecution?
You'll never get to that.
It's never gonna reach a threshold that
if that's your argument, you've lost. I get it, and I don't disagree that there's some issues there, but you're never going to convince an appellate court that you were hard done by on that issue.
Yep. Lindsay, I'm still bumping against the issue of her complaining about being stopped from doing her work and the deadline when it was her pushing for as short of a deadline as possible for the change of venue. It's not the deadline. The deadline was the one red herring she put forward. Like if she put forward a red herring, it was the deadline. She was pissed that it was that issue. The survey became a problem. I'm your Huckleberry, off topic. Hey, Rob, sent you a package. Hope it made it. I have to check. I haven't been to the post office box in a while. Don Burke, what about the Delphi case? Would love your thoughts. That's an intense case. I need to do a whole lot of research on that. MLS is not Major League Soccer. MLS is MLS law. Let me see if I can't pull that up real quick. YouTube. So where I will be tomorrow, building Legos and talking about topics. I haven't built Legos in a long time. Here, MLS, making law simple. So I'll be on with MLS law tomorrow. Building Legos, having fun. Haven't done that in a while. And Ian sent us a palette cleanser, which we're going to go ahead and play. We're going to swoop to palette cleanse, swoop, because we need it. Palette cleanse, incoming. the caption on the video reads the following. Wait, I can't see it. Well, I'll read it later.
I don't know if you need the caption. It's self-explanatory.
It's a little javelina, right?
Run the...
Get him. Get him. Don't get him. Get him. Get him. Nope. 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 God. It is a javelina. Or is it a domestic pig? It's a little piggy. There's a lot of bad jokes I can make that are not appropriate for anyone in law enforcement. Did they just come to mind when I said like I did not think about that originally. But you know what? Good for, you know what? Corner him, use the hips, and got him. Solid tackle. That's a good move. That's a good move. Now that right there, one, like that cop looks like a badass cop. I'm not going to lie. He's probably run down a lot worse than that pig. Yep. So was that in Utah? Was it here?
I'm not sure.
The caption of that was, let me see if I can see the news because Ian shared that with me. Officer tackles pig after 2 days of avoiding police. 2 days? A rogue pig was taken into custody by
most of my clients don't make it 2 days.
2 days? That pig should give seminars.
No, I'll just say, I sent you the link directly because I saw this one shared with a lot of captions that you probably couldn't read out.
No, I wasn't going to do that. That's why I also did the video full screen so you couldn't see any of the other stuff.
Any of the comments.
The comments were interesting because, you know, comments get that way. Anyways, Diddy ended himself up in some trouble, so let's swoop to that. Diddy and the Diddy lawsuit. Well, did he done it? Did he? Oh, the Diddy saga is going to be the Diddy saga for quite some time. Diddy's house was raided. Where did I save that article? I did it. I saved it in my backstage. Let's see if I can't. So a couple of things were reported. Now, usually I don't like to share, you know, things like TMZ, but it's freaking celebrity gossip. Find me a better reporter than TMZ on celebrity gossip.
I know one.
Who?
EDB.
Who reads TMZ?
Yeah, but she also like actually looks up
double checks it. Well,
yeah.
And what I'm about to share on the Diddy gossip, at least this Diddy gossip, EDB's already shared. So it's kind of a preview thing. So the preview thing,
like EDB is like TMZ who's done her homework.
Oh, I agree. So TMZ is reporting that Cassie is cooperating with the feds in the probe. So we have a cooperating witness who just happened to have settled with Diddy after making some very salacious allegations in line with what the prosecutors are believed to be investigating. But apparently she's in touch with the authorities in the federal investigation. Not just that, we're told she's cooperating, as are others who have sued him. Now, Lil Rod came out and said that he has not been contacted or cooperated with any of the investigating authorities yet. I imagine that yet might change.
That kind of sounds like he's making the call me gesture with his finger and his thumb.
Just a bit. Like, I haven't been contacted yet. Like, you can give me a call. Here's my number. Yet, as the number flashes on the screen.
Yeah.
Sources with direct knowledge tell us I always hate that. Cassie's among the witnesses the feds have been in contact with in connection with the Diddy investigation. We're told she's been working with investigators for several weeks, presumably even before Diddy's homes were raided. That does not surprise me because the homes being raided.
Of course she was.
I mean, you filed a lawsuit. The lawsuit was, here are all of the allegations that also correspond with federal crimes. The feds are going, maybe we should call her. And they call her, and they're surprised to find out that she has knowledge of that. And you know what is an express carve out of any settlement agreement? Cooperation with law enforcement. So an individual can settle a claim being brought against them for civil damages. Right? So Cassie sued Diddy. That lawsuit settled within a day of that thing being filed, basically. And those settlement agreements are always usually put in the form, and in that agreement, there's usually a non-dissemination or a what's a better phrase? Ian, what's the word I'm looking for?
I don't know.
Can't talk about the case.
Oh, NDA.
NDA. Yeah, non-disclosure agreement is usually part of it. But there's an exception to an NDA, which is cooperation with any lawful investigation, which an NDA, you cannot preclude somebody contractually from cooperating with the government, which is a problem for Diddy.
Yeah, I mean, especially in criminal investigations, you can't because otherwise every criminal organization would have an NDA. And it would just be like, hello, new recruit, you have to sign this NDA. And the undercover cop is like, damn it, my one weakness, the NDA.
Dear co-conspirators, if you sign on to Conspiracy A, we will bestow upon you $10,000. In exchange, you agree not to disclose any information to any lawful process, including authorities investigating potential kidnapping and, trafficking. So Diddy is in a world of hurt.
Diddy is in a world of doo-doo is what...
Well, he is. He's in a lot of trouble. When I was looking at this, I started thinking about this. Just about who... Because I'm turning 40 this year. Which means
that's a mistake. Don't do that.
You think I can control that at all?
Have you tried?
Honest answer, no.
I mean, chronologically, I'm 44, but mentally, I'm like 12. So,
okay,
you're doing the math. You're like, yep, no, that checks out.
I kind of am. I'm seeing that. Yeah, that would caught me off guard for a second. Anyways, I remember Diddy back when he was Puff or Puffy or Puff Daddy. These are the things that I remember. I remember high school where he was on a screen and there was always somebody with him. He wore the big ass puffy jackets. He was walking around the yellow, the orange. Back was popular back then. And it took me a second to really process this. Like what would it mean for someone like him to become the center of an investigation? How much dirt does he have? How afraid are people of him? I mean, there was the dude that had the island that I won't say on the stream.
Okay, I was wondering if you couldn't remember his name.
No, I remember.
They're okay with you saying his name now.
Oh, okay, I can say the name. There was the Epstein stuff. And Epstein had a little black book that was rather dense. There's a lot of names in there. And I started processing in my mind. Diddy, even when he was Puff Daddy, he had a lot of names in his little black book. A whole lot of names. And it wasn't just rappers. It was a lot of people. So what I saw in the news today that really caught my interest was that reportedly his one of his producers, Stevie J, gave a reminder via his Instagram that everyone parties with Puff. Stevie J posted a video, I'll play in a second, that is Diddy's biggest PR offensive to date. And the message is clear. Check out who parties with Diddy, because it's virtually every big celeb in Hollywood.
That seems to have a message to it.
Would you view that as a, hey, you really want to start talking about this? It's a highlight reel of his 50th birthday bash in 2019. So let's go ahead and take a look at that particular highlight reel. I'll mute it just in case there's any music.
I wasn't invited.
No, so there's the Hollywood sign, Hollywood, Beverly Hills.
Someone's asking, did he party with Baldwin? Obviously not, because nobody died.
Yeah. So Hitman Stevie J is the name, Instagram name. And you guys were just take a look at everyone who's here at the 50th birthday party. There's Diddy himself. There's a big boat. Well, that's a lot of people. It's more people. Oh, yep. All the big names. Now, he posted this 2 days ago after the raid on the houses. All the zoom ins. Oh, there was Cat Williams. Yep. Everyone hanging out at the Diddy party.
Yeah, I didn't get my invite. It must have been lost in the mail.
It was probably lost for everybody. And that's what you're going to see. Because this is speculation. This is how the game is being played. The government knows that they can basically prosecute, well, a lot of people in this video, probably, if they were at any of his freak out parties or whatever they're called. And
it depends on what they saw, what they were doing, etc.
Exactly what they saw. Now, this video was kind of intended, again, speculation, a little bit of a warning shot. Like, remember, you guys are here. Diddy filmed everything. We filmed his birthday party to this extent where we could make a produced video. There's been allegations in every one of these lawsuits that he had video from every one of these parties. Oh, that's funny. Shiraz, yes, he mingled with politicians, including this one. Now, it doesn't mean anything. That means absolutely nothing at all. Unless the threat gets thrown around that if you go after me, I'm going to try and bring everyone down with me. Which is kind of how the Girardi thing went for so long unreported, and the Epstein thing went for so long unreported. Because Girardi was, if you report me, I'm going to take you out. Right? You're going to lose your career, you lose everything. Epstein was same concept. It's just,
ironically, the person who got taken out was Epstein.
Oh, that's the part you can't say out on the stream.
Well, I mean, there's debate as to who did it. It might have been him.
That's the caveat you can add. Good job, Ian. Making sure the pup is. Oh, wait. Side eye. We have side. Oh, shut the eyes. Side eye. Shut eyes. Side eye. All right. So all of that was released this week. video, the whole possible well, the people that they very much want to emphasize the public might have information. And then today we learned that a lawsuit was filed yesterday against his son. Now, the reporting was it was against his son, but he was also named defendant. So let's take a look at the lawsuit real quick. I haven't read this yet. I've just seen reporting on it. Mm-hmm. There we go. All right. So, lawsuit in the Superior Court, State of California, for the County of Los Angeles. Grace O.
Give it your best go.
If you can pronounce that name.
Omar K.
Grace Omar K. Got it. No problem. Grace Omar K. versus Christian Combs, an individual, Sean Combs, an individual, and John and Jane Does 1 through 10, and ABC Corporations 1 through 10. So a bunch of Jane Does, John Does. The complaint for damages alleges 1, assault, 2, battery, 3, sexual assault, 4, premises liability, 5, aiding and abetting, 6, intentional infliction of emotional distress, and 7, negligent infliction of emotional distress. I will tell you right now, we will probably not have to get into 5, 6, and 7 because they're probably just, yeah. Don Burke, where's the picture of Obama? You can Google that. Diddy Obama photo. It's not in that, but Diddy hung out with J-Lo. Diddy hung out with everybody. Diddy probably hung out with Trump. Diddy probably hung out. I don't know. There's probably photos of Diddy and Biden. There's probably photos of Diddy and everybody. Diddy knew everybody. That's the point. So, plaintiff, Grace, remind me again.
Omar K.
Omar K. Buying through her attorney, alleged as follows. Plaintiff's European Caucasian female who worked as a stewardess in the yachting industry since 2018. Why you have to do the Caucasian thing? That's weird. Plaintiff's love of yachting started at an early age and was the foundation on which she built her career. Through yachting, plaintiff had traveled the world, met many new friends and colleagues, enjoyed a very successful career. Throughout her career, plaintiff has always worked well in teams and received high praises and great feedback from her managers and colleagues. Plaintiff also consistently received exemplary reviews from her clients for her customer service, as well as glowing references over the past few years. Consistently done a good job? Yes. Prior to being sexually assaulted by defendant Christian Combs, paragraph 7 is where we get to the meat of this. Plaintiff planned to work the entirety of her career in hospitality and the yachting industry. Unfortunately, those plans have been derailed due to the trauma plaintiff continues to have as a result of the assault. Lovely arrest photo is placed right in there. That photo was taken on the day of the raid, by the way. I think that's him being detained temporarily while the raid's taking place. Defendant Christian Combs is a 25-year-old. Oh, shit. All right. I wasn't ready for this. I hadn't read this yet. Here we go.
You should have been. This has been reported. This is hilarious. I haven't read it already. I did see this line on Twitter.
This is a good one. Defendant.
It's a good one.
Combs is a 25-year-old auto-tuned and heavily edited rapper.
That's shade, but that is unnecessary shade. I would not have shaded that shade.
Unfortunately, as the saying has it, the apple does not fall far from the tree. Defendant,
I feel like this shade is like completely unnecessary shade.
I don't hate it though. The auto-tune and heavily edited. Defendant Sean Combs, Diddy, who we refer to.
I worry that it's one of those bits of shade that by shading that shade, you make the rest of it look
less significant.
Yeah.
And I don't like this. Like I don't like bringing in his other alleged conduct in your lawsuit. Stick with your case. But I can see why they would do it, because it would be persuasive to many. So defendant,
and there's a certain PR element to these lawsuits too. And I'm not saying that the lawsuits are not meritorious, because I don't know that, but there's also elements that are clearly for the PR.
Oh, yeah.
And I suspect that's because he settled one of those suits in a real hurry. And I suspect that there's some desire that he might settle some of these other suits in a real hurry. And thereby, you can usually get more money on a quick settlement if the other side wants to cave right away.
Yeah.
Because if the other side is quick to cave, is eager to cave, then you're probably going to get an amount that makes you happier, but also you might have to pay your lawyers less, which that eats up a lot of money real fast.
Yep. Defendant Diddy, who's also been arrested on several acts of sexual assault, rape, sexual violence, and drugging, among other deplorable conduct, is the father of defendant Christian, who has seemingly taken after his father and the family business of reckless partying, drugging others, sexual violence, and other illegal conduct. Well, holy shit. If you're going to say something, say it out loud. Wow. Specifically,
EDB sort of describes these as allegations and shade, and there's some real shade going on.
That's not even shade. That's a shot across the bow. Specifically, Christian is the second child of billionaire Diddy.
About allegations and choosing violence.
Yeah, that's a fair assessment. And his late ex-partner, Kim Porter. Upon information and belief, Christian resides in the city of Beverly Hills, yada, yada. Defendant Diddy is a rapper and record executive popularly known by his stage name, Puff Daddy, Puffy, P. Diddy, Diddy, Brother Love, or Love. Sure. Diddy became famous in the early 90s with his record label, Bad Boy Records. He rose to prominence in the music and entertainment industry over the decades and is regularly revered as a hip-hop mogul and top rap/hip-hop producer in the industry. Upon information and belief, Diddy resides in the city of Beverly Hills during the relevant period. Defendants John and Jane Doe's, yada, yada, are individuals who were acting around this time. And then ABC Corps, same thing. They're Doe's. Jurisdiction, sure, no problem. Fact, common, all causes. In or around July of 2022, Grace was working on Victorious, a super yacht built by Ack Yacht and owned and operated by Fraser. Okay. Plaintiff works as a temporary second stewardess for the company. That's the company name, Equiom.
Basically, that yacht is worth more money than you or I together will earn in our entire lives.
We've named like 3 entities, and like one's the owner, one's the operator, one's the staffer. So it's a yacht.
Yeah, that's the kind of yacht you could live on because it is a small city.
Yeah. Like there are yachts and there's things that I call yachts. Like this is a yacht. Like this is a big one. Is a big one. In or about September 2022, plaintiff had been part of the dedicated team at the Monaco Boat Show, significant boat show, tasked with selling charters for Victorious to high net worth clients such as Christian and Diddy. In December 2022, plaintiff and her team were advised that the yacht had been successfully chartered for the 2022 holiday period. Plaintiff changed her personal holiday family plans to accommodate the charter service and flew to St. Martin to prepare the yacht for service. Plaintiff soon learned the client who chartered the yacht was Diddy and his family. Diddy leased the yacht and had full control of the staff and premises of the yacht. That's laying the foundation for premises liability. Although plaintiff was used to working in discreet and VIP environments, this was one of her first times working with an A-list celebrity. Because of this, plaintiff and the rest of the team assigned to the yacht were determined to make the holidays special for Diddy and his family. For the duration of the trip, plaintiff was assigned the 6 p.m. to 6 a.m. shift. That sucks, along with one other crew member. The shift, commonly known as the late shift, was very busy. I imagine with just a late night crowd. 6 p.m. to 6 a.m. is like the peak party hours. Late shift duties included dinner and drink service for the clients in the entire 12-hour period. Dinner and drink service had to be carried out with the minimum staff support or backup during the night shift since only 2 individuals were assigned. That's a staffing issue. If I had someone like Diddy on board, I would double my staff at night. That's neither here nor there. Although Diddy was always typically on the yacht, his sons, Christian and Justin, were staying in a luxury villa nearby, but joining their father aboard the yacht most evenings. During the second week of the charter service, there was a significant amount of partying and drug use, which caused the guests to stay up throughout the night. The makeup of the yacht quickly evolved from just defendant Diddy and his family to include a constant rotation of suspected, sex workers and other A-list celebs, such as French Montana and actor Cuba Gooding Jr. Oh, well, hello there again. You've been in other accusations. Interesting to see you here. Defendant Diddy turned what was sold as a wholesome family excursion into a hedonistic environment. Was it consensual? According to plaintiff, it resulted in an unexpected. Wait, why are you saying according to? You're making the allegation. It resulted in an unexpected increase in workload for her and her colleagues, as well as unwanted exposure to unlawful drug use, sex work, and general chaos. General chaos, fair. Other two, when they're unwanted, not okay. It also created an extremely hazardous environment. For example, guests often demanded drink service until 6 a.m. Staff was often treated with disrespect. Suspected sex workers were sprawled out unconscious about the yacht. It's a Hunter S. Thompson. It's a Hunter S. Thompson novel / movie on a boat.
Did he do the sex workers, though? I thought he was mostly known for drugs.
He was, but there were sex workers involved.
Were there? I admit I'm not a huge follower of his work.
I'm trying to remember. Fear and Loathing. In either event,
not.
And it was difficult to distinguish which bottles of alcohol were laced with drugs and which bottles were not.
The answer is yes.
It is important to note that as a bartender, plaintiff understands the impact of alcohol and likelihood that a person would not generally become intoxicated following one mixed drink. Because of this, plaintiff found it very suspicious that after one shot of De Leon, we saw that in the other lawsuit too. De Leon tequila or one mixed drink, various women on the yacht would be falling over themselves, panicking or passing out. This led plaintiff to reasonably believe that the alcohol given to these women was likely laced with drugs. Plaintiff was aware that Rodney Jones, a producer who was employed to work on the Love album, Off the Grid, was required to be on standby for musical recordings, often late into the night. The Love album, Off the Grid, is the 5th studio album by American rapper and record producer Diddy.
Now, this is a place to be really careful with what you put in, because it's like, I was aware and cooperating with this endeavor to drug women. It's like,
there's she's saying she knows.
Yeah, I have some concerns.
Mr. Jones was accepted as an extended member of the service staff and spent time with the plaintiff at the service bar and piano room where he played the piano. On or about the early morning of December 28, 2022, the evening shift started as normal. At about 5 a.m., plaintiff was messaged on the on-duty phone that defendant Christian would be joining the yacht by tender, a small craft that runs back and forth from the larger yacht and used for servicing and providing support and entertainment to private or charter yachts. Christian wanted to be brought over to Victorious to record in the yacht's makeshift recording studio with Mr. Jones. Ian, can you take over for the next few paragraphs?
Where are we?
Although
it was not unheard of for defendant C. Combs to come aboard at such a late hour, he usually stayed at his dwelling offshore overnight, particularly when there was no party on board on any given night. Defendant C. Combs arrived in the tender and was heavily intoxicated. Plaintiff suspects defendant C. Combs was intoxicated from a mixture of narcotics and alcohol. Upon entering the recording studio, defendant C. Combs immediately started ordering that tequila shots be poured from a bottle of alcohol he may have brought onto the yacht. Ironically, defendant C. Combs was playing Cassie's Me and You was playing in the background. Proofreading was playing Me and You was playing in the background. Cassie was an artist under S. Combs and was his former love interest who also accused S. Combs of serious sexual and mental abuse. Just throw that in there. In the studio, defendant C. Combs asked that plaintiff bring the shots to the recording studio / sun deck, and plaintiff obliged as she was the only serving steward at the time. Plaintiff noticed immediately that he was particularly attentive with her, which she considered very inappropriate. However, plaintiff began to become concerned when he insisted that she take shots of the tequila he may have brought on board the yacht. End of available text.
Under pressure and wanting to be polite, plaintiff obliged. Prior to this, the plaintiff witnessed Christian create a Black Santa video. Wait, what? What's a Black Santa video? Which showed him demanding
what is
the
that?
What?
A black, like, is that something we're supposed to recognize?
I don't know. It's in quotes, so I imagine we're supposed to know what it is.
Is that something like a, I don't know,
colloquial term that we're supposed to know? You kids with your new age terminology. Black Santa video. What is this?
I hope it's not going to be a sex thing. Are you Googling it?
I don't get it. I'm not going to understand this. Anyways.
Yeah, it might be too old.
Which showed him demanding the captain, various head of departments, and crew take a shot of tequila with him. This was a pattern established by the captain of the yacht and Diddy. Plaintiff felt comfortable knowing that Mr. Jones was present and didn't think anything more of it. She about to throw Jones out of the bus. She felt she would take one shot and he would return her to the pantry. She is. According to the plaintiff, at this point, the mood changed and things became sinister. Defendant Christian insisted that plaintiff stay chatting and that she sit beside him. Plaintiff resisted.
Like creepy music started to play?
Remained polite, asking to leave. Defendant Christian became aggressive and insisted that plaintiff take a further shot and sit beside him. Red flags, alarm bells. At this point, Christian violently grabbed plaintiff's arm and began hurting her. He pulled plaintiff to the seat beside him and prevented her from getting up. Plaintiff insisted that she had to return to the pantry, but her pleas fell on deaf ears. Angered, defendant Christian forced plaintiff to take another shot. Plaintiff was quite scared and realized that she was in a very dangerous situation. Plaintiff was also feeling the effects of tequila shots and quickly suspected tequila was spiked. At this point, the situation escalated and plaintiff started to be physically assaulted by Diddy. He touched plaintiff's legs. That's a lot. All of her parts. Timeline became blurry and vague to plaintiff.
The parts of A to V, basically.
Basically everything. Yep.
Yeah.
Heads, fingers, knees, and toes, and everything in between. At this timeline, at this point, it became very blurry and vague to plaintiff as she does not recall exactly what happened to her due to the effects of the spiked tequila shots. Luckily for plaintiff, due to defendant Diddy's insistence on Mr. Jones recording everything, oh shit. Mr. Jones has an audio recording of defendant Christian drugging and sexually assaulting plaintiff. Below is the transcript of Christian.
Wait, we don't need a transcript of that.
Well, the fact that they are quoting a transcript means that in case like the defendant is sitting here going, no, I deny, the transcript says I have things that will back this up. Christian,
transcript says, are you sure?
Yeah. Yo, it shot a clock. Not doing shots, Christian. Everybody, we got to take a shot. I'll just put the ledge. No, take the whole thing. No, you take it as well. Take the whole shot. Coming I'm only doing it as long as you take it as well. Ain't gonna lie, I'm not taking nothing. Please take the shot. Wait. He says I'm not taking nothing. Please take the shot. Then she goes, "Are you are drugging me?" Question. Take the shot. Hey, yo, play another beat one time because now below is the additional. This whole thing was recorded. Plaintiff, this is not an offer. You said what? I can't. I'm swapping out. I can't do it. I'm sorry, darling. No, we need you. I'm gonna stop. Stop. I have to go. I have to go. Honestly, I'm like already losing sleep. I have to go now. You're the best thing on the ship, though. What do you mean? Who's going to replace you? Who's going to replace me? Fuck that. It's going to be trash, though. You feel me. Excuse me. You don't touch my legs like that. I'll move my legs where I want to. If I want to do this, then I will. You don't touch my legs like that. Listen, you and everybody in the crew. It's great. I can't. I have to go now. I have to go now. I have to go now. No, yo, tell me, listen, blah, blah, blah. Like you said, this is a lot. Yes. Who can I talk to right now? Who can I talk to? I'm going to say I requested you right now. Well, you can take your hand off my ass for the first thing. According to the plaintiff, she said she would have to be requested because she knew anyone of authority would approve the request was asleep. Defendant Christian would not be able to contact him and plaintiff could then leave. Let's see. Shortly after returning to the pantry, Christian called for plaintiff. He went looking for her and demanded she find him a place to sleep on the yacht. Such a late hour, there were no spare cabins. Oh, yeah, because he was only visiting. Despite this, he refused to go back to shore. The most acceptable place for him to sleep that night was in the cinema. The yacht has a cinema.
Yes, it's a super yacht.
Yeah. Plaintiff directed in the cinema, which was commonly used as an extra sleeping area. The cinema has one door to exit and enter. Plaintiff entered the room and defendant Christian blocked her from exiting. This.
So are you feeling homicidal yet?
Now,
if
granted,
not, why not?
Granted, these are allegations.
Yeah, but you don't allege a transcript unless you got the audio.
You don't allege a transcript unless you have a transcript.
Because that's a great way to get yourself into a world of crap.
Plaintiff retreated to the corner of the room and defendant Christian became physically extremely aggressive. He cornered her and started to grope her. She pushed him back constantly. Christian then took off all his clothes and was trying to force plaintiff to perform certain acts with him. Plaintiff began fighting Christian, and not long after, her partner on board entered the cinema. This startled the defendant, Christian, and the plaintiff was finally able to leave. Plaintiff's partner became concerned and went looking for the plaintiff after she had not returned to her room, and her shift had ended. Presumably, there's a witness. So apparently someone walked in. The morning after, plaintiff complained to the yacht's captain. Well, there's a log of that too. The captain berated the plaintiff. He lacked compassion or concern. That's a problem. Failed to investigate and insist the plaintiff was probably voluntarily partying with the guests. She was not. This is the part of where there's a dialogue of like, believe all women. I hate all of the dialogue surrounding any of this. I have said, take the facts for what they are alleged to be in any specific circumstance. Apply common sense. Give an opportunity for the other side to respond. Vet out the difference. Right now, we have one side of the allegations. We have the allegations. We don't have the response. So right now,
kill them all, let God sort it out.
But if you're going to allege reports to a captain, there's a log. If you're going to allege that there was a transcript, there's a recording. if you're going to allege that it was interrupted, there's a witness. These are the people I want to hear from. Plaintiff was 25 years old. Defendant Diddy's employees, including his drug. Oh, we named Brendan Paul, who's been arrested, drug mule. His chief of staff, Christina Coram. Well, that's the person who is alleged to have arranged other things for him. And his second in line, Frankie Santella, another person, learned of what occurred and informed defendant Diddy. Shortly after, Captain received a generous tip from Diddy in order to keep Captain quiet and keep him from protecting plaintiff or taking action on her behalf. Only a few members of the ship staff were required to write statements. Plaintiff and her partner were the only two staff members not interviewed and not asked to write a statement. Well, there's documents to back that part up, hopefully. Below are images of her bruises. Oh, shit. Yep, that's a wrist bruise.
Yeah, that's a grab bruise.
That's a hand.
Yeah.
Now,
Now,
fingers up here.
Rob and I both recognize this immediately because
we
do criminal law and he does family law. So this is a very common domestic violence injury.
That's a hand. That's a index finger on the top. And then the longer pattern, that's the middle and the ring finger. And then that bruise there is the thumb.
Yep, that's a grab mark.
Shit.
Yep.
According to plaintiff, past year, 2023 has been the most deeply traumatizing time of her life. Assault and cover-up orchestrated by Diddy and his staff. Isolated retaliated against on the yacht. Isolation retaliation resulted in termination. In addition to losing her employment, lost her longtime partner with whom she had planned a future. Partner was never the same after seeing plaintiff's bruises on her body. Here's the question. This is me just playing lawyer. Yes, you see the bruises. Yes, you hear the allegations that Christian is the one that put the bruises on her. There is another dynamic on this boat, the partner, the long-term partner. It would not be beyond reason that there would be an encounter that would result in some form of argument that could result in marks like that. There is more to learn from all of this because we don't know. This is
where the audio recording becomes a big deal.
This is where the audio and any other pictures become a very big deal. And honestly, what the response is, we don't know what the answer is going to be. So,
I suspect that the answer is going to be a lot of paragraph X is denied, paragraph Y is denied, paragraph.
Yeah, but there's going to be depots. It's civil.
Oh, yeah, but that's a ways away.
I tell you what, the people that are coming, these lawsuits against the Lil Rod lawsuit was bad. The Cassie lawsuit, and when I mean bad, I mean the allegations are serious as AF. Cassie lawsuit, allegations are serious AF.
Oh, yeah. I mean, if any of this is borne out by the police investigations, some folks may die in jail.
This is fucked up.
Maybe they'll share a cell with that guy from that 70s show. Masterson.
Yep. So the Diddy allegations are focused on the fact that he was the person responsible for the yacht, that he encouraged and enforced the environment that led to this, that he didn't have any safeguards in place to ensure against the drug use. That's a weak accusation, honestly. Like, you shouldn't have to put safeguards in place to enforce against something you shouldn't anticipate in the first place.
Yeah, except I'm sure it wasn't like this. Oh, this
I
is
know.
unanticipated.
And that's the next, like, kind of paragraph.
Like, who are all these people doing drugs on my drug yacht? I mean,
Yeah. Drinking the alcohol that I am like part owner / spokesperson of, and the problem is, well, not the problem. The problem for Diddy is that,
I mean, there's many problems for Diddy.
well, this is another one. Like, this tracks. That's the problem. Like, this story tracks largely in line with the allegation of the Cassie's lawsuit and the allegation from Lil Rod's lawsuit. Again, they're just allegations, but ostensibly,
I mean, of course they track, right? I don't think that's a huge thing, because if you were writing a BS lawsuit, you'd make it line up, right? But I don't think it's a BS lawsuit. I think that there's going to be some real... This one feels like one where they're not showing us the receipts, but they're telling us we got receipts.
And they're telling you what's in the receipts. Not, they're not showing you. They're just saying, we have them, and this is what they say.
Yeah. So more problem for the Combs family. And I go back to, what was this paragraph? Where was it? Christian Combs, the 25-year-old auto-tuned and heavily edited rapper. You know, there's a great way to not have these kinds of problems.
Just don't do the things.
Keep your hands to yourself.
Just don't do the things. Yeah. Well, that was intense.
You picked a cheerful story, Rob.
I really did. Son of a bitch. I read the article about it.
And you thought, this is a cheery story. Everyone will like this.
No, I didn't. And I expected the lawsuit would have a bunch of receipts in there, and I expected the lawsuit would be something significant. What's frustrating is seeing, one of the things that I'm concerned about is, one, I think that a lot of the allegations, I would like to see them not line up so perfectly with the other allegations, the other complaints, and I would like to not see them cross-reference each other. That part kind of bothers me. Because when you're cross-referencing another complaint, one could argue in response that you're piggybacking off of those allegations and just trying to add in to the individuals that are seeking recourse, right?
And that also gets you to, yeah, no kidding, they correspond, because clearly the lawyers have read both, right?
Yep. But that audio recording is going to come out.
Oh, the odds that gets leaked are very high.
It's very high. And the thing is, when you think about that was one person on one yacht on one night expressing one incident.
Yep.
And there was an audio recording corresponding. Diddy has been in this game for how many years?
At least 2.
Mm-hmm. Times 10. So 20 plus years, probably 30 years in the rap game. 20 years of being an absolute mover and shaker in the rap game. And one night on a yacht, there's a recording. And then you see past allegations that There's recordings from all the other parties or the other things. Oh, and you learn the recording is being taken by somebody who's purported to be from Diddy's camp. Now,
somebody's saving all the bodies.
Well, and now you start to see why the feds were going, give me the digital.
Oh, yeah.
All the phones, all the hard drives, everything. Now, I did want to make a point. Everyone is wanting to see the Diddy criminal charges. I want to tell you guys, get ready for the disappointment. And not the disappointment in the criminal charges being brought, but what I'm telling you is get ready for the fact that those charges are going to be less than what you want them or think that they should be. You see a lot of dirt that's floating out there, but the feds are only going to charge what they can prove. So that's one.
I mean, that's a bold statement.
Yeah, SBF, they dismissed, what, 5 counts?
Yeah, and I mean, there have been plenty of other cases where we see charges laid, and it's like, yeah, what could you actually prove versus what could you allege?
I know.
Not so much.
There's going to be a whole lot of rug sweeping going on in this case. Because a whole lot of people are in that black book. And even
his problem might be that he didn't invite enough FBI agents onto his boat.
I think there were enough. I don't know. Fuck if I know. People in power. So even if the charges get brought, one, a whole lot of deals are going to get cut. They can make a lot of people very uncomfortable. Very uncomfortable. Like there's going to be deals that are going to be cut where it's like, you get to keep all of your money and keep doing exactly what you're doing. And, we're not going to do anything and, live your life because you're testifying favorably in the prosecution of this random person, the Bond villain, odd job. You provided corroborating evidence against odd job. Like, good for you. We're going to let you go. We had enough to convict him anyways, but thank you for doing all the things.
Wait, odd job's involved in this?
No, but I'm pretty sure Diddy has his own odd job, like the version of odd job.
I didn't see any hat throwing allegations.
Have you seen the hats they wear? There's probably at least one. There was a phase that Diddy had where he was wearing the large hats. There might be an allegation around there. It was a phase. Now, granted, a lot of people had that phase. I don't know why, but bad taste.
I mean, I still have bad taste, so.
Bon, will you guys go to the court cases so we can have legit info on it when or if it goes to court? I'm going to go with that second part. If a lot of these things are never going to see a courtroom. Ian, were you saying exactly what I was saying?
I was saying it's a long ways out too. It's like, hey, what are you doing in 3 years? I don't know. As far as I know, I might have been hit by a bus in between now and then.
This is really, really, really early on. It's going to be years of grand juries, correspondence, communications, and then RICO charges are not. I mean, they're fucking complicated, man. Yeah. So, what a lawsuit, right? Oh my God.
Yeah, you picked a fun one.
I didn't intend to. I mean, I was worried about this guy. I didn't know what to do with the chaos agent, the chaos gremlin.
And yet he's been well behaved.
Shockingly. You know what, Ian? Did you drug your client? Did you give him meds?
I did not. He is just a very good dog.
The fact that you emphasized every word of that sentence means I know it's not true. Speaking of this very good dog, wait, can I embiggen Leo for a palate cleanser? I probably can. Let me see. No, there.
Ears. Somebody heard his name. I see a little bit of an eyeball. He raised his eye and then was like,
Somebody just farted. Somebody just farted. Sir.
Rob, that would have been you.
No.
My
No.
client expressly denies any such flatulence.
How can someone sleep that soundly and pass gas that literally could melt paint? I do not understand. I do not get this. Leo.
Oh, big stretch. Head is up.
Yep. I'll take you out in a minute. Hang on. No. All right. Up and mobile. That's my finger. Okay. All right. That said, I woke him up.
Go find something to chew and / or poo on.
What? Where are you going? There you go. You lay down. Yeah, good. Cat, lay down. Good boy. Oh, you're so handsome. Look at you. I see you. Oh my gosh. Drive me nuts. Okay, you can lay down now. It's okay. Lay down.
Leo, there's a carpet that is left woefully unpooped.
No, don't do that. Larry Larrett, thank you. I'm glad he's got a good defense. All we know is what the government told us. If he's convicted, we can be sure he really did it. Catherine Frazier, motion. Rob color codes his curtains. Audacity. Yeah, I did that for NC State. I'm still rooting. So tomorrow night, NC State plays Purdue in the basketballs. So Final Four. So rooting for that. Musical Soup. Thank you for the super sticker. Nick Loss. Thank you, my friend. I have done 1 hour elevator pitches on the Delphi case, and at this point, it is almost impossible to cover the entire case in 1 hour. It's not. It is not. That case is so fucking complicated. Maybe the constitutional part can give you a grasp in 1 hour. Nope, I don't think you can hit that either. It's a complicated case. SF, MLS said he should change it to Lincoln Logs. Oh, I like Legos. Megan Brogdon, there's
You're
nothing
being stereotyped.
I am. I'm being stereotyped. That's very rude. You cannot escape the camera. Megan Brogdon, there's nothing. That's nothing. In Australia, we have a drunken pig wandering around. That's an Australia thing. Alan Muller, I'll never grow up. Not me. You and me too, my friend. And I think Ian as well. Like, I'll grow old.
Now, in Canada, we have the same thing, but unfortunately, they're elected, so nothing can be done about them.
Don't. Oh. You guys, Ian did a video earlier this week that was very controversial, but I will say it was probably the most fair take I've seen on any of it, because what he did was he pulled the damn law up and he read through the law. Everywhere else you see covering this stuff, and what I'm talking about is the right to, or the whether one has a right to assist in their own demise,
or rather to have a medical practitioner assist.
A medical practitioner, yeah. Ian pulled the law up and talked the law talked about the law through the context of one specific case, but highlighting questions on either side. Please go check that video out. I looked at it. It did not have anywhere near the views that it should because it was a really fair interpretation. And God, one of the only times you're ever going to hear people talk about both sides on that issue. Please do. Brian and Jill W., new member. Thank you for becoming a member. Chris Cat Queen, I must be dense. I was just going to his party, supposed to be a warning if you didn't do anything wrong. No, it's when you hear about what happened at parties or other parties.
The thing is, to a certain extent, it doesn't matter if you did anything wrong, because what they can do is leak that you were an attendee.
Yeah, you were there.
And people will assume that you did stuff wrong. So it's probably like, hey, you guys may want to start defending me on this because
yeah. Like, let's put a hypothetical. Like, let's say that the indictment, if there is one, reads as follows. Diddy engaged with somebody in a back room who happened to be a minor. In the back room, he knew it was happening. It was his party. He did it. Also at the party was A, B, C, D, E. The prosecution can put those facts in there. That video was basically, do you want to be named as anyone having to do with any of this, even if you weren't implicated in any of the conduct? Yeah. Free Divine Spirit, you two are my favorite duo. God bless. Thank you, Free Divine Spirit. Melissa Smith, we didn't start the fire, but we're here to feed it, and our children need it. Josh Duggar, Steven Stearns, Epstein Island up in flames. It's a lot going on. With Smith, FBI operations, Guardian, cross country, and renewed hope. Things to look up. Will Smith, Sound of Freedom, I can hear it. Cassie tried, Porter died. We won't listen to your lies. Oh, it was in the tune of We Didn't Start the Fire. I get it now. Just done. Don't disparage Leo.
I agree.
I haven't. He farted. People fart. Dogs fart. His just happened to clear rooms.
Rob, I'm going to be, if you want to have continued association with my client, I'm going to be sending over a non-disparagement clause or agreement for you to review and sign.
What's the additional consideration?
$1.
No, I decline. Sandy, thank you for sharing Leo with us tonight. Thank you, Sandy. Lady Lysandra, MLS.
And my client may have to pursue
MLS meant Leo logs. Leo logs. Yeah, that's fair. Lady Drake sending to confirm.
You don't want to be assembling anything out of Leo logs. I'll just tell you that right now.
Lady Drake sending to confirm that we mods heard Leo pass gas on stream and thought he snorted. Puppy gas is the worst. Yeah, like rotting brat, worst. Oh my gosh. Tammy Fayette, Ian, I tried watching that video and got too upset. That's fair. That's okay. Yep. Just like people get upset about all kinds of things.
Hopefully it wasn't something I said.
No. Pick your lane. You don't want to get into it. Turn it off. That's fine. But if you're interested in the topic or if you've seen reporting on it, this is the other perspective that you should probably take a look at. Bop it. Leo didn't do it. Rob just imagined the smell. Elise, I miss Uncivil. Kurt, is he coming back? Probably at some point. Right now, I'm just trying to manage the very limited time I have on streams. I say that 4 hours in. My bandwidth is so narrow right now.
I just invite myself.
Ian, what you guys don't know.
I have the keys to the back door and I just intrude.
Ian literally has StreamYard admin privileges. And you know what? God bless, I haven't taken those away because he just shows up. Just shows up.
Also because it allows for things like this.
Up here, I didn't do shit.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Yeah, I gave Ian access to everything in return.
And it was a total mistake.
Ian gave me access to everything back. When I tell you that there's a level of trust between he and I'm not effing around. So when he's able to join, it's never an expectation. It's always a pleasure. I always love having him on. He and I make fun of each other and talk to each other all week long. And I love when we get to hang out on these streams, whether it's Monday, Friday, any other day in between. I love it. Whether we're in the chat teasing EDB or Rick or Alita and we're poking fun and causing chaos. I freaking love the dynamic. It's one of the most fun things in the world, and also why I support so heavily. You guys, Ian does a Monday stream, a Monday live stream. I know Mondays are fucking hard. They're really hard. I get it. They're very hard. For me, I oftentimes will be in court or dealing with this chaos gremlin or navigating the dynamics of two little mini mischiefs that are complicated. Mondays are hard. You know what's not hard? Listening. So when Ian goes live on Monday, just tune in, throw it in the background, listen to it, watch it. If you feel inspired or have some fun, send a chat. If it's a super chat, great. If it's a membership gift, great. If you're already a member, awesome member chat. Please show support. Like Ian is here every freaking weekend. Every Friday, he's always here.
And I'm here because I enjoy it.
Yeah.
Like, it's a lot of fun.
Yeah. And it is so, I wish schedules would align that would behave.
That's not how the world works.
No, it's not. It's not. Because I have like this very limited scope when I can actually get online. I go,
it's
how many days without responding to our group chats?
Oh God.
Don't
yeah,
say
Rob
that.
Is like,
don't say it all that. No.
Because your client will respond?
No.
Yeah, it's a lot.
I know that I disappoint some people with some of the takes I have.
Oh, you always will. I mean, that's just the thing. Is there's no way to be everything to everyone. And that trying is a fool's errand.
Yeah. I'm doing my best. And the thing is, my best actually involves managing a certain chaos gremlin that's not the dog sleeping behind me. It's the person that has gray hair that's on the screen. So Ian is one of the most fun people I've ever interacted with.
But I also cause trouble.
Who causes all the trouble. So please, if you're watching this right now, his channel link is pinned in the description. Just click over and subscribe. And do me the favor of showing up on Monday. So please, if you wouldn't mind. Very much appreciate it. Thank you guys for being here. Catching up, Adrian Angevine, Runkle, please add a clause for better food to that non-disparagement agreement. Poor food equals stinky gas. All Rob's fault. Leo is framed. Come on. Really? He is happy and healthy. He's a lovely pup. Kathy Trout, your life would be easier if Leo had a sister. Kathy Trout, I can manage a lot of things right now. Another dog is not one of them. It's just not.
I gotta say, Potter and Zora get along really well. And earlier, amusingly as hell, Potter has a much thicker coat than Zora. So Potter was all about like, I want to go play outside. And Zora was like, I am down for this for short periods. And Potter was like, no, we got to go play outside. And Zora's like, I've had enough of that. I'm coming in. And then Potter would keep like insisting that we open the door so that he could try to lure Zora out. And she's like, it's still cold out there, my dude. I will do this when it's like not cold.
Yeah, like look at me playing with you from like the inside of the house where it's warm. Look at me play from inside.
It was the cutest thing because it was like Potter kept being like, come on out, play. And Zora's like, still freaking cold out there. This is not happening.
Yeah. Dogs they have opinions. This one has opinions. He has a lot of opinions. Ian, your client has opinions.
I mean, of course he does.
You know what? Fuck you. I'm sorry. That was really rude. Your client has the same personality. I will try to argue logic, and he is like, F that. I don't want to hear it. What is going on? Feed me my treat.
He's like, I've got better logic than you do.
Yeah, like I'm going to bite all your fingers while you feed me treat. Just, you know what? That's why I said that. How did you get into his head? How did you get into his head?
It's not his fault that the fingers are now treat flavored.
No, they are not. You have
if not treat, then why treat flavored?
Oh, he did it again. Oh, son of a bitch. Oh my God. That was so bad. How are you asleep? How are you unconscious?
See, he knows when you're talking crap about him.
Yeah, because he craps back.
And he's got a defense mechanism.
He's not a skunk. All right.
You say that, but like, what's that smell?
Yeah, what's that smell? That smell is I'm going to take him out to try to evacuate the bowels because good reminder, MLS Law, making law simple. MLS Law, I will be on with MLS Law tomorrow evening, 9 p.m. Eastern Standard Time, where I will be assembling a lovely Lego Up house, like the house from Up.
Oh, cool. I want to pick up the D&D set, although it's expensive.
Yeah. So I will be on with MLS. We've been pushing this off for, I think, like 4 months now. And I finally said, doing it. Because I set that part of time. I set the time apart. And I put it on my calendar. It's there. Done. So, yes. Tomorrow night, MLS Law. Please check that out. I will try to put that in the description of this video. And I will see you guys then. Let me catch up on these. XCDA, enjoy your weekend. Everyone enjoy their weekend. Please get outside, enjoy something. Go make something, have some fun. Baby Gator, I hear Ian doesn't like cash gifts.
Did you get the context for that one?
I did not.
I was talking about
the last context I have.
I was talking about Janet and how she really screwed up by telling the internet what pisses her off, because she was so upset that people are calling her Janet that that she actually put in her filing that this annoyed her. And I was like, oh God, don't ever do that. The internet will hear that this annoys you.
I remember this. I'm going to buy cash. Yep.
And then I was like, and so personally, I'm very upset when I get cash gifts.
Yep. I do remember that. Yep. By the way, I love you and hate you for putting that video of me hysterically laughing at Jeanette Braun. Like there's the sun and everything under it. And that's what
everyone loves that video because it's hilarious.
Like that's what she wants. She wants to enjoy the sun and everyone under it shall no longer say that I'm a bad lawyer. You cannot say I'm a bad lawyer.
It's so ridiculous.
Anyways, yeah, Ian had great pleasure, and I laughed my ass off again watching that again. Darlene, get Zora a Swester.
Swester? Like a Southwester hat?
Or a sweater. You get sweater.
Oh,
warm.
She does not like wearing a sweater.
A lot of dogs don't like wearing clothes.
Yeah, she's not a like a pants kind of dog.
Yeah. Leo needs a name badge on a screen. Chad is saying they want to see the freaking video. Do you have it, Andy?
I think so. Give me a second.
Sad Tiger says Leo needs a name badge on his screen. I tried. It won't let me do it. It's an alternate camera, so it's messing with me, so it won't let me say it. But I mean, he's Leo. He's cute. Look at him. He's freaking cute. Melissa Smith, baby gator, and he hates hot sauce. Arlene Navo, Leo's farts equals his version of court objections. Yeah. They're about as loud. Yeah. Yeah. Silent but deadly. Yeah. Okay. Fair.
I've been covering the Janet Braun lawsuit. This is messed up because it's going to be cut. This is the before I cut it down version. So I've got my face moved over so that I can cut it down for TikTok.
That's fair. If the world wonders, is he shedding? My pupper eats his own loose fur and turns into a chemical weapons factory when he does. No, he is just eating things that I cannot catch him fast enough before he eats it, like grass or random shit on the floor. And I have him leashed. He has a 15-foot lead. So
you heard him admit that there is random shit on the floor. That's a Rob Fault problem.
Ian, swear to God, drop the lawyer stick for 2 seconds. I am trying my best. Like he does great with his trainer, and I have tried to reinforce a lot of that stuff. He actually really does well with place. He does place, he does sit, he does bed, he does shake, he does chin. Like he puts all of it. He's very, very, very good. He loves training. So he is on a 15-foot lead for a lot of the day. But even with that lead, fucking Dobermans are quick as shit. They are so fast and they are so willful. You turn your head for a second and he's on the fucking counter or he's doing something. And you're like, oh my God, you little. They require a vigilance that is holy crap level. And I am fighting my best and doing my best. You may continue, sir.
Yeah, it just sounds like you got to, you got to baby proof the place.
He's getting taller. Like the baby proofing was on the counter, things were back. Within a week, fucking dog can get not just on the counter, but he's like all the way into the counter. It's like, how did you do that?
Yeah, you got to teach him that the counter is a no-go zone.
Ian, you want to come visit and teach him? You are more than welcome to have a conversation with your client because your client is difficult.
I'm afraid I've got to represent my client's interests as opposed to.
Oh my God. And he wants a counter. Son of a bitch. The ethical obligation strikes again. Second time this video, the ethical obligation strikes again. All right, let her rip.
Okay. As many of you know, I've been covering the Janet Braun lawsuit over on my YouTube channel. Now, on my Monday live stream, I decided to share a bit of this with a friend of mine because it's hilarious. Specifically, where they're asking for an injunction and just how ridiculous that injunction is. Now, this is Rob from Law and Lumber, and he's another attorney. So let's check out his reaction. They want an order permanently enjoining defendants and their respective partners, agents, representatives, successors, assigns, and employees, and any and all persons in active convert or participation with defendants, and each of their executors, administrators, successors, licensees, assigns, subsidiaries, parent affiliates, divisions, co-venturers, partners, officers, directors, employees, agents, shareholders, managers, representatives, consultants, and any and all other persons, corporations, or other entities acting under the supervision, direction, control, or on behalf of any of the foregoing, and each of them from making, disseminating, broadcasting, or publishing any statements that plaintiff Propson
Wait, pause.
Yeah. Wait. Hold up. Let's revisit. Before we do the scroll down,
half of any of the
currently enjoining everyone, all the people, partners, agents, representatives, successors, assigns, employees. If you are in active convert, when was the last time I saw that fucking phrase? Or participation with defendants.
Oh, this is way too long. This is not the right version. Let me take that down.
That's fine. That's a lot of fucking people, man.
Let me
that's everyone.
Let me see if I can find the right version. It's on my TikTok. Do you have the ability to pull up my TikTok?
I can download the video quickly. Yeah, I think I do. You shared it on. Let me find our group chat.
I think I found it. No, I've been covering the Janet Braun lawsuit over on my YouTube channel. Version here. Now, on my Monday live stream, I decided to share a bit of this with a friend of mine because it's hilarious. Specifically, where they're asking for an injunction and just how ridiculous that injunction is. Now, this is Rob from Law and Lumber, and he's another attorney. So let's check out his reaction. They want an order permanently enjoining defendants and their respective partners, agents, representatives, successors, assigns, and employees, and any and all persons in active convert or participation with defendants, and each of their executors, administrators, successors, licensees, assigns, subsidiaries, parent affiliates, divisions, co-venturers, partners, officers, directors, employees, agents, shareholders, managers, representatives, consultants, and any and all other persons, corporations, or other entities acting under the supervision, direction, control, or on behalf of any of the foregoing, and each of them from making, disseminating, broadcasting, or publishing any statements that plaintiff Propson
Wait, pause.
Braun is an unethical lawyer.
You deserve a pause. You deserve a pause. That was a whole lot. Take a breath. That was a lot. that was a lot.
To be fair, this was like 1 a.m. my time.
Oh yes,
on a Monday.
But you got to see Rob's reaction.
It was a lot on a Monday at 1 a.m.
That was the sun, and then everyone under it.
We want an injunction banning everyone on the planet.
Like there's the sun and everyone who like reaps benefit of that sun. They were like, all of it, please. Yeah. No.
Like
no,
the First Amendment analysis on this is basically the court is going to have two rulings on this particular request, and the first ruling is going to be go, and the second ruling is going to be fuck yourself.
This was a real filing. This is real.
This is a real filing.
This isn't made up. This is real.
This is their amended, amended complaint where they're trying to fix it.
No, it's not.
They're shareholders. Like,
One, it is very embarrassing to hear yourself laughing out loud. Like, it's a very embarrassing thing to perceive. Two, I 1000% stand by the laughter. Like that is.
Is this not the most ridiculous thing you've ever seen?
It was also just very fucking genuine.
You form a corporation and you buy a share, you'd be enjoying.
Oh, how drunk was I? No, it was. I was stone cold sober. It was like 1 a.m. my time on a Monday. So no, this was.
He was a little tired, but that's it. He was just.
I was in the shop. I'm not in the shop drunk.
Yeah. Gates saying Ms. Braun is a rogue attorney.
You can be the random person on the street and you can't say that she's a bad attorney.
I think we broke Rob.
Please bar the person that sold me my hot dog from saying I'm a bad lawyer. Oh my god. Oh man. Oh, this is not possible.
See,
it literally says if you are under the sun, you cannot call me a bad lawyer.
Now I want to have now I want to see if I can convince like Caffeinated Kitty to start a corporation and then sell shares of that corporation so that you can literally sell pieces of an injunction.
No, you can't. I'm sorry. It's like if you've heard of this lawsuit, you can't call me a bad lawyer. if you've heard of this lawsuit, you cannot talk about my name. Oh my god, this is not a real filing.
This is a real filing. It's like we want to enjoin like Caffeinated Kitty's pool cleaner because as an employee is not allowed to say bad things to Jack Braun.
If you happen to have a cell phone, with Twitter notifications, you can't say anything bad about me. You can't call me a bad lawyer.
Oh my god, it's so
I need that so bad. I need that so bad. Oh, okay.
It's the most ridiculous thing ever.
Yeah. Ian read me that lawsuit. It was a long day. And Lady Drake says, Jarvis did me dirty. Jarvis is my camera down in the shop. Jarvis was doing the zoom in, zoom out thing that Jarvis does. No, that lawsuit was that ridiculous. Like you cannot enjoin.
It's so
one,
bizarre.
you can't enjoin opinion. Like you're a bad lawyer. That's an opinion. Two, you can't issue that injunction against literally everyone you interact with. Like that's not a lawful thing. I can't just say, hey, I met you, told you about this lawsuit. Now you're enjoined from ever criticizing the lawyer that was the lawyer in the lawsuit. I wanted to die. Like that was.
Oh, it's just the dumbest thing.
Jeanette Braun will be a. She's the gift tree that keeps on giving.
Oh, I anticipate that. I mean, unless she grabs a clue, that is a possibility that she, that her and Common Sense managed to find their way into the same room. But
no.
Absent that, I mean, I'm just gonna keep on laughing at her because
she and Common Sense, they had a cordial relationship. Like in high school, they were friends. But she put like Common Sense on the she put Common Sense in the friend zone like a long time ago, and has kept a firm distance away from Common Sense since then.
Oh, I mean, she's in a lawsuit where she is co-plaintiffs with a client. How does this happen?
That is all the conflicts. That is all the conflicts and all the waivers at one time.
Oh, that's all the
waivers and conflicts.
You have
time.
You have literally put your privilege, like, I mean, assuming this doesn't get thrown out, which there is a very good chance it does.
Gasoline.
There is a very good chance that, you know, we're going to see an application saying, hey, privilege has got to go.
Yeah.
And
the thing is, she voluntarily filed it. She filed it.
Well, and let's say that they do breach privilege. You know what you then see is a complaint from Lauren the Mortician. And because Lauren the Mortician may have an excellent case against this on the basis of, like, against Janet, on the basis of, I didn't know I'd be waiving privilege. Why did you not advise me?
Which is something that everyone watching this stream right now should go check out on Ian's channel. Yes, exactly. Go check that out on Ian's channel, because Ian has been covering the hell out of this case. You know what? Do it right at the end of the stream. I'm gonna do this.
I got a playlist on this. It's like 10 hours of video.
Wait, you do? Hang on.
Yeah,
there's a redirect. I can do that now.
Oh, I mean, there's a playlist on it, but it's like 10 hours of video. It's great for a day when you're stuck at work and you just need something to listen to. It might be a little much for late at night.
People can save the playlist.
That's fair.
They can save the playlist. Let me do this right now. Hang on. Customization. Nope. It's in the details part. Nope. Customization part. Redirect. Runkle. Runkle of the Bailey. Why is YouTube so annoying? Hang on. Let me do this way. YouTube. Ian, can you pull up some of those chats while I'm doing this real quick, please? If
sure.
you wouldn't
One
mind.
second. I will. Yeah, let's see. Analytical Blarney AB says, thank you for all you guys do. You two are the best. I don't know if that's Alberta. If so, howdy, neighbor. Elizabeth Webster, thank you so much for the membership there. And Analytical Blarney AB, thank you for the 5 gifted memberships. Patty Hoffman, tried Doggy Probiotic. I think that is to reduce the fartiness.
Oh.
If it hits the ground, it belongs to the hound.
That's fair.
Analytical Barney AB, thank you for another 5 gifted memberships, and another gifted membership, and another gifted membership, and another gifted membership. Wow, hitting it hard there. Catastrophe, Breaking Rob was the highlight. It was great. And then 5 gifted memberships. MZ, you guys are such a pair, lighting up the night sky. And there's a thumbs up to remind people to hit the like button, as well as a heart. And KPT, thank you for the 1 gifted membership. And Lindsay says, Rob, how goes packing up the shop?
The packing of the shop is going to be a adventure. There's a lot. Ian, you've seen the shop. Like, you've seen.
You got a lot of cool stuff.
Yeah. So I have to get like actual, I'm hiring tech packers, people that are used to packing like technology that can't be shifted and moved.
What you should do is just have them put like some of the most fragile stuff, like your CNC machine and so forth, into a box and just send it to me.
Or
Rob's like, or I could not do that.
not. No, so I'm using like tech packers to basically pack up the stuff and try to move it on time.
That
The
makes
shop
sense.
is being organized for like listing photos, because realistically, like getting everything out of there before I have a place to put it, not going to happen. It's a big shop. It's not a big shop. There's a whole lot going on in that shop. So that's
Reasonable.
So I could not set up the redirect from the live, but what I know I can do is the second the video ends, I can put an end card that will send you to that playlist, and I will do just that. So for those of you on Replay Crew, please check out the Laura and the Mortician series. And for those of you who caught the live, please check out Andrea Burkhart, who is phenomenal. Thank her for coming along. Thank her for joining tonight in the discussion about, well, a crazy case in Idaho. Thank you, Ian. As always, much appreciated. We are 4 hours and 45 minutes in, which means that it is 1:24 a.m. my time after a full week and evening and day of work. So we're going to call it a wrap. Thank you guys for being here. Much appreciated. Ian, parting thoughts?
Don't do what Janet does.
And I got to take this little guy out for a little bit of a walk. We're going to spend some quality time. He's going to go back to bed.
You got to get some exercise into him, and then get some stank smells out.
I'm going to get some exercise, get him a little run, let him do the poopy thing, and then let him go to bed, because it's a tough life. You know what? I will sometimes, like when I finish a stream and Mischief is like on the computer downstairs, similar, like leg out, like sideways, like passed out. Fair comparison. Oh, the feeder. Look at the paw. Look at the paw. Look at the paw.
At this hour, Zora is look at the paw.
I know. He's like, what do you see? What do you see, buddy? What do you see?
He's chasing something.
Did you get it? Nope. Still getting it? Did you get it?
Of course, the problem is he'll learn that like this is prime pooping time when you want it to be prime sleeping time.
No, he's good. He did great tonight. He was the star of the show.
Oh,
he's quiet.
The problem is I can't set up a Zora cam, because the Zora right now is going to be trying her best to snuggle Mrs. Runkle. And I'm not putting a camera on Mrs. Runkle while she tries to sleep. That would not be conducive to my continued, marriage.
Yeah.
And I mean, I just finished making an amazing an amazing ramen. So I don't want to burn all of that credit like right away.
Yeah, the ramen part, like I need your recipe. I don't think you're going to share it because I think it probably changes all the time, but
I can give you like instructions as to how to make a ramen. It's a lot of boiling.
You know what? It's probably like arroz con pollo. Like you can have a recipe and fuck up the recipe every time. You just have to learn how to do it. And when you learn how to do it, you do it right. So, all right. You had a thought. You had a very, you had an expressive thought. You're muted. Yep, gotcha.
All right, so you hear me now? What is it? It's a lot of effort, but a lot of it comes down to being diligent, and then also the tare that you use. and you've I don't know if I can give away my secrets on that, but I can give you sort of where to start. Yeah. A ton of it is you boil it and you boil it and you boil it and you boil it, and then eventually, you know how you know when it's done? Because you've got like bones, and the bones have some meat on them, right? You know it's done when you could pick out a piece of meat, wait for it to cool. Don't put it in your mouth right away or you will die. Wait for it to cool and then taste it. And if it tastes like anything other than disappointment, then you have made the wrong thing. Then it's not ready yet. It's got to boil more. So, but it's also a really good winter food because during the summer, all of that boiling in the house, you will hate your life because it'll just dump heat into your house.
Yeah, we talked about that one. All right. Everyone, for cooking tips, please follow Runkle. Not like burn your face off tips, but we're gonna get out of here. It is now 4 hours and 49 minutes. Oh, someone has woken up, which means I have to give that one a treat and take him out.
Now he's listening. You want the meat to taste like disappointment, and when the meat tastes like disappointment, the broth will taste amazing. It's the meat fragments, and all of those get skimmed out. Like those are going in the garbage. That's where they're destined.
Yep. So we got big stretch coming. Oh, nope. Back. Nope. Leo, we're going out. We're going outside. We're having a treat. You want a treat? Go outside.
He's like,
right.
Leo hears you. Leo don't care.
All right. Outro incoming. Thank you guys for being here. Much appreciated. Thank you for being here. Happy Friday. Happy weekend to all of you. I will catch you guys on the next time. Thanks for showing some love to everybody, and good night.